Welcome to The Docket. I'm your host, Corey Snow. This is episode 25. In September of 2023, a group of Republican and unaffiliated voters in Colorado filed a lawsuit against the Secretary of State of Colorado, asserting that the Secretary was not allowed to include Donald Trump's name on the presidential primary ballot for the 2024 presidential election because they claimed that Trump had violated Section 3 of the 14th Amendment to the Constitution by engaging in an insurrection against the United States on January 6, 2021, and was therefore barred from holding the office of president. At the conclusion of that case, District Court Judge Sarah B. Wallace ruled that Trump did engage in insurrection, but that Section 3 of the 14th Amendment did not apply to the office of the president and ordered the Secretary of State to place Trump on the ballot. Upon appeal, the Supreme Court of the state of Colorado took up the case. On December 19, 2023, they issued a ruling that affirmed the district court's conclusion that Trump did engage in insurrection, but overturned the part of the ruling which concluded that the presidency was not covered by Section 3 of the 14th Amendment, and therefore that Donald Trump was constitutionally ineligible to be president, ordering that Trump not be allowed on the ballot. The ruling was immediately stayed pending a likely appeal to the United States Supreme Court. What follows is an audio narration of the Colorado Supreme Court's decision. Please note that footnotes and most citations are simplified or omitted entirely to improve listenability. The audio also does not include the 3 dissenting opinions which were published at the same time. The original document, including all citations, footnotes, and the dissenting opinions, is available at a link provided in the show notes. The Supreme Court of the State of Colorado. Supreme Court Case Number 23SA300. Appeal pursuant to state law. District Court, City and County of Denver. Honorable Sarah B. Wallace, Judge. Petitioners, appellants, cross appellees: Norma Anderson, Michelle Priola, Claudine Camarada, Christine Kafer, Kathy Wright, and Christopher Castilian, v. Respondent appellee; Jenna Griswold in her official capacity as Colorado Secretary of State; and intervenor appellee, Colorado Republican State Central Committee, an unincorporated association. Intervenor appellee, cross appellant, Donald J. Trump. Order affirmed in part and reversed in part, en banc, December 19, 2023. Lists of attorneys omitted. Per curiam. More than 3 months ago, a group of Colorado electors eligible to vote in the Republican presidential primary, both registered Republican and unaffiliated voters, the electors, filed a lengthy petition in the District Court for the City and County of Denver, Denver District Court, or the District Court, asking the court to rule that former President Donald J. Trump, President Trump, may not appear on the Colorado Republican presidential primary ballot. Invoking provisions of Colorado's Uniform Election Code of 1992, the Election Code, the electors requested that the District Court prohibit Jenna Griswold, in her official capacity as Colorado's Secretary of State, the Secretary, from placing President Trump's name on the presidential primary ballot. They claimed that Section 3 of the 14th Amendment to the U.S. Constitution, Section 3, disqualified President Trump from seeking the presidency. More specifically, they asserted that he was ineligible under Section 3 because he engaged in insurrection on January 6, 2021, after swearing an oath as president to support the U.S. Constitution. After permitting President Trump and the Colorado Republican State Central Committee, CRSCC, collectively intervenors, to intervene in the action below, the District Court conducted a 5-day trial. The court found, by clear and convincing evidence, that President Trump engaged in insurrection, as those terms are used in Section 3, But, the district court concluded, Section 3 does not apply to the president. Therefore, the court denied the petition to keep President Trump off the presidential primary ballot. The electors and President Trump sought this court's review of various rulings by the district court. We affirm in part and reverse in part. We hold as follows. The election code allows the electors to challenge President Trump's status as a qualified candidate based on Section 3. Indeed, the election code provides the electors their only viable means of litigating whether President Trump is disqualified from holding office under Section 3. Congress does not need to pass implementing legislation for Section 3's disqualification provision to attach, and Section 3 is, in that sense, self-executing. Judicial review of President Trump's eligibility for office under Section 3 is not precluded by the political question doctrine. Section 3 encompasses the office of the presidency and someone who has taken an oath as president. On this point, the district court committed reversible error. The district court did not abuse its discretion in admitting portions of Congress's January 6th report into evidence at trial. The district court did not err in concluding that the events at the U.S. Capitol on January 6, 2021 constituted an insurrection. The district court did not err in concluding that President Trump engaged in that insurrection through his personal actions. President Trump's speech inciting the crowd that breached the U.S. Capitol on January 6, 2021 was not protected by the First Amendment. The sum of these parts is this: President Trump is disqualified from holding the office of president under Section 3. Because he is disqualified, it would be a wrongful act under the election code for the Secretary to list him as a candidate on the presidential primary ballot. We do not reach these conclusions lightly. We are mindful of the magnitude and weight of the questions now before us. We are likewise mindful of our solemn duty to apply the law without fear or favor and without being swayed by public reaction to the decisions that the law mandates we reach. We are also cognizant that we travel in uncharted territory and that this case presents several issues of first impression. But for our resolution of the elector's challenge under the election code, the Secretary would be required to include President Trump's name on the 2024 presidential primary ballot. Therefore, to maintain the status quo pending any review by the U.S. Supreme Court, we stay our ruling until January 4, 2024, the day before the Secretary's deadline to certify the content of the presidential primary ballot. If review is sought in the Supreme Court before the stay expires on January 4, 2024, then the stay shall remain in place, and the Secretary will continue to be required to include President Trump's name on the 2024 presidential primary ballot until the receipt of any order or mandate from the Supreme Court. 1. Background. On November 8, 2016, President Trump was elected as the 45th President of the United States. He served in that role for 4 years. On November 7, 2020, Joseph R. Biden, Jr. was elected as the 46th President of the United States. President Trump refused to accept the results, but President Biden now occupies the office of the President. On December 14, 2020, the Electoral College officially confirmed the results: 306 electoral votes for President Biden, 232 for President Trump. President Trump continued to challenge the outcome, both in the courts and in the media. On January 6, 2021, pursuant to the 12th Amendment, U.S. Constitution Amendment 12 and the Electoral Count Act 3 U.S.C. Section 15, Congress convened a joint session to certify the Electoral College votes. President Trump held a rally that morning at the Ellipse in Washington, D.C., at which he, along with several others, spoke to the attendees. In his speech, which began around noon, President Trump persisted in rejecting the election results, telling his supporters that, quote, "We won in a landslide," end quote, and, quote, "We will never concede," end quote. He urged his supporters to, quote, "confront this egregious assault on our democracy," end quote, "walk down to the Capitol and show strength," end quote, and that if they did not, quote, "fight like hell, they would not have a country anymore," end quote. Before his speech ended, portions of the crowd began moving toward the Capitol. Below, we discuss additional facts regarding the events of January 6th as relevant to the legal issues before us. Just before 4 a.m. the next morning, January 7, 2021, Vice President Michael R. Pence certified the electoral votes, officially confirming President Biden as President-elect of the United States. President Trump now seeks the Colorado Republican Party's 2024 presidential nomination. 2. Procedural history. On September 6, 2023, the electors initiated these proceedings against the Secretary in Denver District Court under various sections of state law. In their verified petition, the electors challenged the Secretary's authority to list President Trump, quote, "as a candidate on the 2024 Republican presidential primary election ballot and any future election ballot, based on his disqualification from public office under Section 3, end quote. President Trump intervened and almost immediately filed a notice of removal to federal court, asserting federal question jurisdiction. In light of the removal, the Denver District Court closed the case on September 8th. On September 12th, the federal district court remanded the case back to state court, concluding that it lacked jurisdiction because the electors had no Article III standing and the Secretary had neither joined nor consented to the removal. Once the electors filed proof with the Denver District Court that all parties had been served, the court reopened the case on September 14th. At a status conference 4 days later, on September 18th, the Secretary emphasized that she must certify the candidates for the 2024 presidential primary ballot by January 5th. The court set the matter for a 5-day trial, beginning on October 30th. On September 22nd, with the parties' input, the court issued expedited case management deadlines for a host of matters, including the disclosure of expert reports, witness lists and exhibits, as well as for briefing and argument on several motions. The court also granted CRSCC's motion to intervene on October 5th. On October 11th, the Secretary's office received 1. President Trump's signed and notarized statement of intent to run as a candidate for a major political party in the presidential primary, 2. The approval form for him to do so, signed by the chair of the Colorado Republican Party, asserting that President Trump was, quote, bona fide and affiliated with the Republican Party, end quote, and 3. The requisite filing fee. On October 20th, the District Court issued an omnibus order addressing many outstanding motions. Regarding President Trump's motions, the court reached 3 conclusions that are relevant now. 1. The elector's petition involved constitutional questions but remained, quote, a challenge against an election official based on her alleged duties under the Election Code, end quote, and, quote, such a claim was proper under Section 1-1-113 as a matter of procedure, end quote. 2, quote, Section 1-4-1204 expressly incorporates Section 1-1-113, and Section 1-1-113 does not limit challenges to acts that have already occurred, but rather provides for relief when the Secretary is about to take an improper or wrongful act, end quote. Thus, because the electors had alleged such an act, the matter was ripe for decision, and 3, it could not conclude as a matter of law that the 14th Amendment excludes a candidate from the presidential primary ballot or that the Secretary has the authority to determine candidate qualifications, so those issues would be determined at the trial. Regarding CRSCC's motions, the Court, in relevant part, concluded that the state does not violate a political party's First Amendment associational rights by excluding constitutionally ineligible candidates from the presidential primary ballot, but also rejected CRSCC's argument to the extent it purported to raise an independent constitutional claim beyond the proper scope of a Section 1-1-113 proceeding. On October 23, President Trump filed a petition for review in this court, asking us to exercise original jurisdiction to halt the scheduled trial. 4 days later, we denied the petition without passing judgment on the merits of any of President Trump's contentions. On October 25, the District Court denied President Trump's 14th Amendment-based motion to dismiss. As relevant now, the court concluded that 1. It would not dismiss the case under the political question doctrine, but it reserved the right to revisit the doctrine, quote, to the extent that there is any evidence or argument at trial that provides the court with additional guidance on whether the issue of presidential eligibility has been delegated to the United States Congress, end quote. 2. Whether Section 3 is self-executing is irrelevant, because Section 1-4-1204 allows the Secretary to exclude constitutionally disqualified candidates and states, quote, can and have applied Section 3 pursuant to state statutes without federal enforcement legislation, end quote. And 3. It would reserve for trial the issues of whether Section 3 applies to a president and whether President Trump had engaged in insurrection. The trial began, as scheduled, on October 30th. The evidentiary portion lasted 5 days, with closing arguments almost 2 weeks later on November 15th. During those 2 weeks, the electors, the Secretary, President Trump, and CRSCC submitted proposed findings of fact and conclusions of law. The court issued its written final order on November 17th, finding by clear and convincing evidence that the events of January 6th constituted an insurrection, and President Trump engaged in that insurrection. The court further concluded, however, that Section 3 does not apply to a president because, as the terms are used in Section 3, the presidency is not an office under the United States, nor is the President an officer of the United States who had previously taken an oath to support the Constitution of the United States. U.S. Constitution Amendment 14. Accordingly, the Secretary could not exclude President Trump's name from the presidential primary ballot. On November 20th, both the electors and President Trump sought this court's review of the district court's rulings under state code. We accepted jurisdiction of the parties' cross-petitions. Following extensive briefing from the parties and over a dozen amici, we held oral argument on December 6th and now issue this ruling. 3. Analysis. We begin with an overview of Section 3. We then address threshold questions regarding 1. Whether the election code provides a basis for review of the elector's claim, 2. Whether Section 3 requires implementing legislation before its disqualification provision attaches, and 3. Whether Section 3 poses a non-justiciable political question. After concluding that these threshold issues do not prevent us from reaching the merits, we consider whether Section 3 applies to a president. Concluding that it does, we address the admissibility of Congress's January 6th report, the report, before reviewing and ultimately upholding the district court's findings of fact and conclusions of law in support of its determination that President Trump engaged in insurrection. Lastly, we consider and reject President Trump's argument that his speech on January 6th was protected by the First Amendment. A. Section 3 of the 14th Amendment and Principles of Constitutional Interpretation. The end of the Civil War brought what one author has termed a second founding of the United States of America. See Eric Foner, The Second Founding, How the Civil War and Reconstruction Remade the Constitution. Reconstruction ushered in the 14th Amendment, which includes Section 3, a provision addressing what to do with those individuals who held positions of political power before the war, fought on the side of the Confederacy, and then sought to return to those positions. Section 3 provides, "No person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid and comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability." United States Constitution, Amendment 14, Section 3. In interpreting a constitutional provision, our goal is to prevent the evasion of the provision's legitimate operation and to effectuate the drafter's intent. To do so, we begin with Section 3's plain language, giving its terms their ordinary and popular meanings. If the language is clear and unambiguous, then we enforce it as written, and we need not turn to other tools of construction. However, if the provision's language is reasonably susceptible of multiple interpretations, then it is ambiguous, and we may consider the textual, structural, and historical evidence put forward by the parties. And we will continue the provision in light of the objective sought to be achieved and the mischief to be avoided. These principles of constitutional interpretation apply to all sections of this opinion in which we address the meaning of any constitutional provision. B. The state court has the authority to adjudicate a challenge to presidential candidate qualifications under the Election Code. The elector's claim is grounded in 2 sections of the Election Code. They argue that it would be a breach of duty or other wrongful act under the Election Code for the Secretary to place President Trump on the presidential primary ballot because he is not a qualified candidate based on Section 3's disqualification. The electors therefore seek an order pursuant to the Election Code directing the Secretary not to list President Trump on the presidential primary ballot for the election to be held on March 5, 2024, or any future ballot. President Trump and CRSCC contend that Colorado courts lack jurisdiction over the elector's claim and that the electors cannot state a proper claim under the Election Code, in part because the elector's claim is a constitutional claim that cannot be raised in an action under this court's decisions in Frazier v. Williams, 2017, and Kuhn v. Williams, 2018. CRSCC also argues that the Secretary lacks authority to interfere with a political party's decision-making process or to interfere with the party's First Amendment right of association to select its own candidates. Lastly, President Trump argues that the expedited procedures under the Election Code are insufficient to evaluate the elector's claim. Before considering each of these arguments in turn, we first explain the standard of review for statutory interpretation and then provide an overview of the Election Code provisions at issue. Turning to interveners' contentions, we first conclude that the district court had jurisdiction to adjudicate the elector's claim under the Election Code, but recognizing that the ability to exercise jurisdiction here does not mean the electors can state a proper claim under the Election Code, we explore whether states have the constitutional power to assess presidential qualifications. We conclude that they do, provided their legislatures have established such authority by statute. Analyzing the relevant provisions of the Election Code, we then conclude that the General Assembly has given Colorado courts the authority to assess presidential qualifications and, therefore, that the electors have stated a proper claim under the Election Code. We next address interveners' related arguments and conclude that limiting the presidential primary ballot to constitutionally qualified candidates does not interfere with CRSCC's associational rights under the First Amendment. Finally, we conclude that the Election Code provides sufficient due process for evaluating whether a candidate satisfies the constitutional qualifications for the office he or she seeks. 1. Standard of review. We review the district court's interpretation of the relevant statutes de novo. In doing so, our primary objective is to effectuate the intent of the General Assembly by looking to the plain meaning of the language used considered within the context of the statute as a whole. When a term is undefined, we construe a statutory term in accordance with its ordinary or natural meaning. If the language is clear, we apply it as written. If, however, the language is reasonably susceptible of multiple interpretations, we may turn to other tools of construction to guide our interpretation. These may include consideration of the purpose of the statute, the circumstances under which the statute was enacted, the legislative history, and the consequences of a particular construction. We also avoid constructions that would yield illogical or absurd results. 2. Presidential primaries under the Election Code. Before addressing the merits, we provide a brief overview of the Election Code's provisions relating to presidential primary elections. Article 7, Section 11 of the Colorado Constitution commands the General Assembly to, quote, pass laws to secure the purity of elections and guard against abuses of the elective franchise, end quote. Pursuant to this constitutional mandate, the Secretary's duties under the Election Code include supervising the conduct of primary and general elections in the state and enforcing the provisions of the Election Code. Part 12 of Article 4 of the Election Code governs presidential primary elections. Colorado Revised Statutes, 2023, explains that, quote, it is the intent of the people of the state of Colorado that the provisions of this Part 12 conform to the requirements of federal law and national political party rules governing presidential primary elections, end quote. This reference indicates that the legislature envisioned Part 12 as operating in harmony with federal law, including requirements governing presidential primary elections. As such, it is instructive when interpreting other provisions of Part 12. The Election Code limits participation in the presidential primary to qualified candidates. Quote, each political party that has a qualified candidate is entitled to participate in the Colorado presidential primary election, end quote. As a practical matter, the mechanism through which a presidential primary hopeful attests that he or she is a qualified candidate is the Statement of Intent, or Affidavit of Intent, filed with the Secretary. The Secretary's Statement of Intent form for a major party presidential primary candidate requires the candidate to affirm via checkboxes that he or she meets the qualifications set forth in Article 2 of the U.S. Constitution for the office of President, specifically that the candidate is at least 35 years old, has been a resident of the United States for at least 14 years, and is a natural-born U.S. citizen. The form further requires the candidate to sign an affirmation that states, quote, I intend to run for the office stated above, and solemnly affirm that I meet all qualifications for the office prescribed by law, end quote. no party has challenged the Secretary's authority to require candidates to provide this information on the Statement of Intent form. The Election Code requires the Secretary to, quote, certify the names and party affiliations of the candidates to be placed on any presidential primary election ballots, end quote, not later than 60 days before the presidential primary election. For the 2024 election cycle, that deadline is January 5, 2024. The Election Code further states, the only candidates whose names shall be placed on ballots for the election shall be those candidates who b. are seeking the nomination for president of a political party as a bona fide candidate for president of the United States pursuant to political party rules and are affiliated with a major political party that received at least 20% of the votes cast by eligible electors in Colorado at the last presidential election, and c. have submitted to the Secretary not later than 85 days before the date of the presidential primary election a notarized candidate's statement of intent, together with either a non-refundable filing fee of $500 or a petition signed by at least 5,000 eligible electors. For the 2024 election cycle, the deadline to submit these items was December 11, 2023. The Election Code allows for, quote, challenges to the listing of any candidate on the presidential primary election ballot, end quote. Any such challenge must be brought, quote, no later than 5 days after the filing deadline for candidates, end quote, and, quote, must provide notice of the alleged impropriety that gives rise to the complaint, end quote. The district court must hold a hearing no later than 5 days after the challenge is filed to assess the validity of all alleged improprieties. The statute does not limit the length or content of the hearing. It does, however, require the district court to issue findings of fact and conclusions of law no later than 48 hours after the hearing concludes. Quote, the party filing the challenge has the burden to sustain the challenge by a preponderance of the evidence, end quote. Challenges under the Election Code must be brought through the special statutory procedure found in Section 11113 for adjudicating controversies that arise under the Election Code. Section 141204, paragraph 4, providing that any challenge to the listing of a candidate on the presidential primary ballot, quote, must be made in writing and filed with the district court in accordance with Section 11113, paragraph 1, end quote, and, quote, any order entered by the district court may be reviewed by the Supreme Court in accordance with Section 11113, paragraph 3. Section 11113 has deep roots in Colorado election law. It originated in an 1894 amendment to Colorado's Australian ballot law, first adopted by the 8th General Assembly in 1891. Much like its present-day counterpart, the original provision established procedures for adjudicating controversies between election officials and any candidate, political party officers or representatives, or persons making nominations. The current version of Section 11113 establishes, with exceptions not relevant here, quote, the exclusive method for the adjudication of controversies arising from a breach or neglect of duty or other wrongful act that occurs prior to the day of an election, end quote. Section 11113, paragraph 4, emphasis added. It provides, when any controversy arises between any official charged with any duty or function under this code and any candidate or any officers or representatives of a political party, or any persons who have made nominations, or when any eligible elector files a verified petition in a district court of competent jurisdiction alleging that a person charged with a duty under this code has committed or is about to commit a breach or neglect of duty or other wrongful act, after notice to the official, which includes an opportunity to be heard, Upon a finding of good cause, the district court shall issue an order requiring substantial compliance with the provisions of this code. The order shall require the person charged to forthwith perform the duty or to desist from the wrongful act. Section 113, paragraph 1. Emphases added. Section 11113 proceedings also provide for expedited, albeit discretionary, appellate review in this court. Either party may seek review from this court within 3 days after the district court proceedings conclude. If the court declines jurisdiction of the case, the district court's decision is final and is not subject to further appellate review. Although Colorado's expedited statutory procedure for litigating election disputes may be unfamiliar nationally, our courts, particularly the Denver District Court, the proper venue when the Secretary is the named respondent, are accustomed to Section 11113 litigation. Such cases arise during virtually every election cycle, and this court has exercised jurisdiction many times to review these disputes. Moreover, it is not uncommon for Section 11113 cases to require courts to take evidence and grapple with complex legal issues. Even early cases recognized that the original 1894 provision, quote, contemplated the taking of evidence where the issues required it, end quote. Layton v. Bates, Colorado, 1897. 3. The district court had jurisdiction to adjudicate the elector's claim under the Election Code. President Trump argues that the district court lacked jurisdiction over the elector's action because the Secretary has no duty under the Election Code to investigate a candidate's qualifications. A district court has jurisdiction pursuant to the Election Code when 1. An eligible elector, 2. Files a verified petition in a district court of competent jurisdiction, 3. Alleging that a person charged with a duty under the Election Code, 4. Has committed or is about to commit a breach of duty or other wrongful act. The district court plainly had jurisdiction under the Election Code to hear the elector's claim. First, the electors are eligible electors within the meaning of the Election Code because, as Republican and unaffiliated voters, they are, quote, persons who meet the specific requirements for voting at a specific election, end quote, namely, the Republican presidential primary election. Second, the electors timely filed their verified petition under the Election Code in the proper district court. Third, their petition was filed against the Secretary, an election official charged with duties under the Election Code. And fourth, the petition alleged that the Secretary was about to commit a breach of duty or other wrongful act under the Election Code by placing President Trump on the presidential primary ballot because he is not constitutionally qualified to hold office. Though it does not affect the district court's jurisdiction, President Trump's assertion that the Secretary does not have a duty under the Election Code to determine a candidate's constitutional qualification raises the question of whether the electors presented a proper claim. To answer that question, we must first determine whether, generally, states have the authority to determine presidential qualifications. 4. States have the authority to assess presidential candidates' qualifications. Quote, common sense as well as constitutional law compels the conclusion that government must play an active role in structuring elections, end quote. Burdick v. Takushi, 1992. The Constitution delegates to states the authority to prescribe the times, places, and manner of holding congressional elections, U.S. Constitution, Article 1, Section 4, Clause 1, and states retain the power to regulate their own elections. States exercise these powers through comprehensive and sometimes complex election codes, regulating the registration and qualifications of voters, the selection and eligibility of candidates, and the voting process itself. These powers are uncontroversial and well explored in U.S. Supreme Court case law. But does the U.S. Constitution authorize states to assess the constitutional qualifications of presidential candidates? We conclude that it does. Under Article 2, Section 1, each state is authorized to appoint presidential electors, quote, in such manner as the legislature thereof may direct, end quote. U.S. Constitution, Article 2, Section 1, Clause 2. So long as a state's exercise of its appointment power does not run afoul of another constitutional constraint, that power is plenary. But voters no longer choose between slates of electors on Election Day. Instead, they vote for presidential candidates who serve as proxies for their pledged electors. Accordingly, states exercise their plenary appointment power not only to regulate the electors themselves, but also to regulate candidate access to presidential ballots. Absent a separate constitutional constraint, then, states may exercise their plenary appointment power to limit presidential ballot access to those candidates who are constitutionally qualified to hold the office of president. And nothing in the U.S. Constitution expressly precludes states from limiting access to the presidential ballot to such candidates. No party in this case has challenged the Secretary's authority to require a presidential primary candidate to confirm on the required statement of intent form that he or she meets the Article 2 requirements of age, residency, and citizenship, and to further attest that he or she meets all qualifications for the office prescribed by law. Moreover, several courts have expressly upheld states' ability to exclude constitutionally ineligible candidates from their presidential ballots. See Lindsay v. Bowen, 9th Circuit, 2014. Upholding California's refusal to place a 27-year-old candidate on the presidential ballot, Hassan v. Colorado, 10th Circuit, 2012, affirming the Secretary's decision to exclude a naturalized citizen from the presidential ballot, Socialist Workers' Party of Illinois v. Ogilvie, Northern District of Illinois, 1972, per curiam, affirming Illinois' exclusion of a 31-year-old candidate from the presidential ballot. As then-Judge Gorsuch recognized in Hassan, it is, quote, a state's legitimate interest in protecting the integrity and practical functioning of the political process, end quote, that, quote, permits it to exclude from the ballot candidates who are constitutionally prohibited from assuming office, end quote. The question then becomes whether Colorado has exercised this power through the election code. We conclude that it has. Section 1.4.1204, paragraph 4, is Colorado's vehicle for advancing these state interests. When eligible electors challenge the Secretary's listing on the presidential primary ballot of a candidate who is not constitutionally qualified to assume office, Section 1.4.1204, paragraph 4, as exercised through a proceeding under Section 1.1.113, offers an exclusive remedy under the Election Code. The electors have stated a proper claim that is not precluded by Frazier and Kuhn. President Trump argues that the electors' claim cannot be properly litigated in a Section 1.1.113 action because the Secretary has no duty under the Election Code to investigate a candidate's qualifications and because this court's precedent bars the litigation of constitutional claims in a Section 1.1.113 action. Although we agree that the Secretary has no duty to independently investigate the qualifications of a presidential primary candidate, we conclude that the electors may nevertheless challenge a candidate's qualifications under the Election Code, and that the electors' claim here is not a constitutional claim precluded by our decisions in Frazier and Kuhn. In presidential primary elections, the Secretary's duty is to, quote, certify the names and party affiliations of the candidates to be placed on any presidential primary election ballots, end quote. The conditions that must be satisfied before she can exercise this duty are limited to timely receiving 1. Confirmation that the prospective candidate is a bona fide candidate under the party's rules, 2. A notarized statement of intent from the candidate, and 3. The requisite filing fee, or a petition signed by at least 5,000 eligible electors affiliated with the candidate's political party who reside in Colorado. Where a candidate does not submit or cannot comply with the required attestations on the Statement of Intent form, the Secretary cannot list the candidate on the ballot. See Hassan v. Colorado, Colorado 2012. But if the contents of a signed and notarized statement of intent appear factually complete, i.e., the candidate has filled out the Secretary's form confirming that he or she meets the Article 2 requirements of age, residency, and citizenship, and further attesting that he or she meets all qualifications for the office prescribed by law, the Secretary has no duty to further investigate the accuracy or validity of the information the prospective candidate has supplied. To that extent, we agree with President Trump that the Secretary has no duty to determine, beyond what is apparent on the face of the required documents, whether a presidential candidate is qualified. The fact that the Secretary has complied with her duties under the Election Code does not, however, foreclose a challenge under the Election Code. As discussed above, the Election Code permits, quote, any challenge to the listing of any candidate on the presidential primary election ballot, end quote, using Section 11113, Paragraph 1 as a procedural vehicle. Section 11113, Paragraph 1, in turn, creates a cause of action for electors alleging a breach of duty or other wrongful act under the Code. Section 11113 then requires the district court, not the election official, to adjudicate an eligible elector's challenge to a candidate's eligibility. As we have explained, the Secretary has complied with her limited duty to accept President Trump's properly completed paperwork. But the electors have alleged an impending wrongful act, which is more expansive than a breach or neglect of duty. Indeed, Section 11113 clearly comprehends challenges to a broad range of wrongful acts committed by officials charged with duties under the Code, including any act that is inconsistent with the Election Code. We conclude that certifying an unqualified candidate to the presidential primary ballot constitutes a wrongful act that runs afoul of the Election Code and undermines the purposes of the Election Code. Nothing in Section 1412004, Paragraph 4, limits challenges under that provision to those based on a breach of the Secretary's duties under Section 1412004. And Section 1412003, Paragraph 2, Clause A, clearly limits participation in the presidential primary to political parties fielding qualified candidates. Although Section 1412003, Paragraph 2, Clause A, does not define qualified, nearby provisions regarding write-in candidates indicate that qualified refers to a candidate's qualifications for office. As with bona fide major party candidates under Section 1412004, Paragraph 1, write-in candidates for the presidential primary must file a notarized candidate statement of intent. Under the Election Code, such statements for all write-in candidates, regardless of the type of election, must indicate that the candidate, quote, desires the office and is qualified to assume its duties if elected. The Election Code's explicit requirement that a write-in candidate be qualified to assume the duties of their intended office logically implies that major party candidates under the Election Code must be qualified in the same manner. Reading the Election Code as a whole, then, we conclude that qualified in the Election Code must mean, at minimum, that a candidate is qualified under the U.S. Constitution to assume the duties of the office of President. It has to, as Section 141203, Paragraph 2, Clause A supplies the only textual basis in the Election Code for the Secretary's authority to require a presidential primary candidate to attest to his or her qualifications for office in the candidate statement or affidavit of intent. Moreover, to read qualified not to encompass federal constitutional qualifications would undermine the purpose of the Election Code, to secure the purity of elections, while compromising the Secretary's ability to advance that purpose. We therefore reject such an interpretation as contrary to the purpose of the Election Code. Instead, we conclude that under the Election Code, qualified candidates for the presidential primary are those who, at a minimum, are qualified to hold office under the provisions of the U.S. Constitution. We recognize that the Supreme Court has twice declined to address whether Section 3, which disqualifies an oath-breaking insurrectionist from holding office, amounts to a qualification for office. But lower courts, when presented squarely with the question, have all but concluded that Section 3 is the functional equivalent of a qualification for office. We perceive no logical distinction between a disqualification from office and a qualification to assume office, at least for the purposes of the Election Code claim here. Either way, it would be a wrongful act for the Secretary to list a candidate on the presidential primary ballot who is not qualified to assume the duties of the office. Moreover, because Section 3 is a, quote, part of the text of the Constitution, end quote, assessing a candidate's compliance with it for purposes of determining their eligibility for office does not improperly, quote, add qualifications to those that appear in the Constitution, end quote. U.S. Term Limits, 514 U.S. at 787. Doing so merely renders the list of constitutional qualifications more complete. Nor are we persuaded by President Trump's assertion that Section 3 does not bar him from running for or being elected to office because Section 3 bars individuals only from holding office. Hassan specifically rejected any such distinction. There, the candidate argued that even if Article 2, quote, properly holds him ineligible to assume the office of president, end quote, Colorado could not, quote, deny him a place on the ballot, end quote. The Hassan panel concluded otherwise. In any event, the provisions in the Election Code governing presidential primary elections do not recognize such a distinction. Rather, as discussed above, those provisions require all presidential primary candidates to be constitutionally qualified before their names are added to the presidential primary ballot, pursuant to Election Code. Were we to adopt President Trump's view, Colorado could not exclude from the ballot even candidates who plainly do not satisfy the age, residency, and citizenship requirements of the Presidential Qualifications Clause of Article 2. It would mean that the state would be powerless to exclude a 28-year-old, a non-resident of the United States, or even a foreign national from the presidential primary ballot in Colorado. Yet, as noted, several courts have upheld states' exclusion from ballots of presidential candidates who fail to meet the qualifications for office under Article 2. Lastly, we reject President Trump and CRSCC's argument that state courts may not hear the elector's claim because this court's precedent bars the litigation of constitutional claims in a Section 11113 action. See Frazier and Kuhn. The electors have not asserted a constitutional claim, so Frazier and Kuhn do not control here. Both Frazier and Kuhn addressed whether a petitioner could shoehorn a claim challenging the constitutionality of the Election Code into a Section 11113 proceeding. In Frazier, we concluded that Section 11113 is not a proper vehicle to resolve claims under 42 U.S.C. Section 1983 because they do not arise under the Election Code and because the sole remedy available under Section 11113 is a court order directing compliance with the Election Code. Similarly, in Kuhn, we held that to the extent the candidate sought to challenge the constitutionality of the petition circulator residency requirement under the Election Code, the court lacked jurisdiction to address such arguments in a Section 11113 proceeding. Here, however, the electors do not challenge the constitutionality of the Election Code, nor do they allege a violation of the Constitution. Instead, they allege a wrongful act under Section 11113. That the elector's claim has constitutional implications or requires interpretations of a constitutional provision does not make it a separate constitutional claim of the sort prohibited by Fraser and Kuhn. And neither President Trump nor CRSCC suggests that a Section 11113 claim cannot have constitutional implications. Indeed, as the Secretary notes in her brief, there is nothing particularly unusual about a Section 11113 proceeding raising constitutional issues. As discussed above, the elector's claim is that the Secretary will commit a wrongful act under the Election Code if she lists a candidate on the presidential primary ballot who is not qualified for office. While this claim requires resolving constitutional questions, it remains a challenge brought by eligible electors against an election official regarding an alleged wrongful act under the Election Code. Section 11113 is the exclusive vehicle for litigating such challenges prior to an election. The electors have no other viable option. 6. Limiting presidential primary ballot access to constitutionally qualified candidates does not interfere with CRSCC's First Amendment rights. CRSCC argues that the Election Code vests it with the sole authority to determine who the Republican nominees will be on a ballot, a reflection, CRSCC contends, of its constitutional right to freely associate and exercise its political decisions. Taken to its logical end, CRSCC's position is that it has a First Amendment right to deem any person to be a bona fide candidate pursuant to their party rules, and subsequently mandate that individual's placement on the presidential ballot, without regard to that candidate's age, residency, citizenship, see U.S. Constitution Article 2, Section 1, Clause 5, or even whether the candidate has already served 2 terms as president. See Ibid at Amendment 22. Quote, "No person shall be elected to the office of the president more than twice," end quote. We disagree with this position. As a threshold matter, we acknowledge that the District Court dismissed CRSCC's argument on this issue, ruling that it raised a separate constitutional claim improperly litigated in a Section 11113 action. We agree that a claim challenging the constitutionality of the Election Code cannot be reviewed under Section 11113. But to the extent that CRSCC argues in its answer brief that the Secretary lacks authority to interfere with CRSCC's associational rights, we respond briefly to those concerns. We distinguish between 1. CRSCC's right to decide the candidates with whom it affiliates and recognizes as bona fide, and 2. CRSCC's ability to place candidates on the presidential primary ballot. CRSCC's, quote, "claim that it has a right to select its own candidate is uncontroversial so far as it goes." Timmons, 520 U.S. at 359. Partisan political organizations enjoy freedom of association protected by the First and 14th Amendments. Kashjan v. Republican Party of Connecticut, 1986, and, quote, "As a result, political parties' government structure and activities enjoy constitutional protection," end quote. Timmons, 520 U.S. at 538. In other words, CRSCC is well within its rights to choose with whom it affiliates and to decide which candidates it recognizes as bona fide. Quote, "It does not follow, though, that a party is absolutely entitled to have its nominee appear on the ballot as that party's candidate," end quote. Ibid at 359, noting that, quote, "a particular candidate might be ineligible for office," end quote, for example. As a practical matter, any state election law governing the selection and eligibility of candidates affects, to some degree, the fundamental right to associate with others for political ends. Even so, quote, there must be a substantial regulation of elections if they are to be fair and honest, and if some sort of order, rather than chaos, is to accompany the democratic processes, end quote. Burdick, 504 U.S. at 433, quoting Storer v. Brown, 1974. Accordingly, to determine if a state election law impermissibly burdens a party's associational rights, courts must weigh the character and magnitude of the burden imposed by the rule, quote, against the interests the state contends justify that burden, end quote, and then consider whether the state's interests make the burden necessary. Limiting ballot access, quote, to those who have complied with state election law requirements is the prototypical example of a regulation that, while it affects the right to vote, is eminently reasonable. Burdick. Here, the election code limits presidential primary ballot access to only qualified candidates. Such a restriction is an eminently reasonable regulation that does not severely burden CRSCC's constitutional rights. To hold otherwise would permit political parties to disregard the requirements of the law and the Constitution whenever they decide as a matter of political expression or political choice that those requirements do not apply. That cannot be. The Constitution, not any political party rule, is the supreme law of the land. U.S. Constitution, Article 6, Clause 2. 7. Section 11113 proceedings provide adequate due process for litigants. Lastly, President Trump asserts that Section 11113 is not a valid way to litigate complex constitutional, legal, and factual issues. He complains of unfairness inherent in the expedited procedures that Section 11113 demands. But President Trump's argument disregards how the elector's claim proceeded here. Initially, we note that to the extent President Trump purports to challenge the constitutionality of Section 11113 under the 14th Amendment's Due Process Clause as a defense to the elector's claim, he raises precisely the type of independent constitutional claim he recognizes is barred by Kuhn. As discussed above, constitutional challenges to provisions of the Election Code fall outside the scope of a proper Section 11113 challenge because these expedited statutory proceedings entertain only one type of claim, election officials' violations of the Election Code, and one type of injunctive relief, an order compelling substantial compliance with the Election Code. Furthermore, because Section 11113 proceedings are designed to address election-related disputes, they move quickly out of necessity. Frazier, quote, given the tight deadlines for conducting elections, Section 11113 is a summary proceeding designed to quickly resolve challenges brought by electors, candidates, and other designated plaintiffs against state election officials prior to Election Day, end quote. Lawyers who practice in this area are well aware of this. Looming elections trigger a cascade of deadlines under both state and federal law that cannot accommodate protracted litigation schedules, particularly when the dispute concerns a candidate's access to the ballot. And a state's interest in, quote, protecting the integrity of the election process and avoiding voter confusion, end quote. Lindsay, citing Timmons, allows a state to expedite the process by which a candidate's qualifications, once challenged, are subsequently determined. That the form of Section 11113 proceedings reflects their function to expeditiously resolve pre-election disputes over an election official's wrongful act does not mean these proceedings lack due process. Nor does the need for expedited proceedings in election disputes preclude a district court from using traditional means of case management in a Section 11113 proceeding to construct a schedule that accommodates legally or factually complex issues. President Trump contends that the expedited nature of Section 11113 proceedings do not provide the time for the kinds of procedures he believes the complexities of this case require. For example, filing CR-CP 12 motions testing the legal sufficiency of the elector's claims before the litigation proceeds, allowing for extended discovery and disclosure procedures, and providing the opportunity to depose expert witnesses. But he has never specifically articulated how the district court's approach lacked due process. He certainly does not contend that he was prejudiced because the district court moved too slowly or failed to resolve the case in a week. He made no specific offer of proof regarding other discovery he would have conducted or other evidence he would have tendered. Moreover, his arguments throughout this case have focused predominantly on questions of law and not on disputed issues of material fact. In addition, the district court took many steps to address the complexities of the case. For example, the first hearing in this case was a status conference on September 18th, 4 days after the case was reopened after being remanded from federal court. In recognition of the complexity of the case, the district court, with the parties' input, adopted a civil case management approach to the litigation that afforded the parties the opportunity to be heard on a wide range of substantive issues. The district court's case management approach worked. After permitting multiple interveners to participate, the district court allowed sufficient time for extensive pre-hearing motions in which all parties vigorously engaged. It then issued 3 substantive rulings on these motions, including an omnibus ruling addressing 4 of interveners' motions, all in advance of the trial. The trial took place over 5 days and included opening and closing statements, the direct and cross-examination of 15 witnesses, and the presentation of 96 exhibits. Moreover, the legal and factual complexity of this case did not prevent the district court from issuing a comprehensive 102-page order within the 48-hour window Section 141204, paragraph 4, requires. In short, the district court admirably and swiftly discharged its duty to adjudicate this complex Section 11113 action, substantially complying with statutory deadlines, while demonstrating the flexibility inherent in such a proceeding to address the various issues raised by interveners. And nothing about the district court's process suggests that President Trump was deprived of notice or opportunity to fully respond to the claim against him or to mount a vigorous defense. If any case suggests that it is not impossible to, quote, fully litigate a complex constitutional issue within days or weeks, end quote, this is it. Frazier. For these reasons, we conclude that the Election Code allows Colorado's courts, through challenges brought under Sections 141204, paragraph 4, and 11113, to assess the constitutional qualifications of a candidate, and to order the Secretary to exclude from the ballot candidates who are not qualified. These provisions advance Colorado's, quote, legitimate interest in protecting the integrity and practical functioning of the political process, end quote, by allowing the Secretary to, quote, exclude from the ballot presidential candidates who are constitutionally prohibited from assuming office, end quote. Hassan. Moreover, these provisions neither infringe on a political party's associational rights nor compromise the validity of a court's rulings on complex, factual, and legal issues. Rather, they provide a robust vehicle through which to protect the purity of Colorado's elections. See Colorado Constitution, Article 7, Section 11. Because the electors have properly invoked Colorado's Section 11113 process to challenge the listing of President Trump on the presidential primary ballot as a wrongful act, we proceed to the other threshold questions raised by interveners. C. The disqualification provision of Section 3 attaches without congressional action. The elector's challenge to the Secretary's ability to certify President Trump as a qualified candidate presumes that Section 3 is self-executing, in the sense that it is enforceable as a constitutional disqualification without implementing legislation from Congress. Because Congress has not authorized state courts to enforce Section 3, interveners argue that this court may not consider President Trump's alleged disqualification under Section 3 in this Section 11113 proceeding. We disagree. The only mention of congressional power in Section 3 is that, quote, Congress may, by a vote of 2/3 of each House, remove, end quote, the disqualification of a former officer who had engaged in insurrection. U.S. Constitution, Amendment 14, Section 3. Section 3 does not determine who decides whether the disqualification has attached in the first place. Interveners, however, look to Section 5 of the 14th Amendment, which provides that, quote, the Congress shall have the power to enforce by appropriate legislation the provisions of this article, end quote, to argue that congressional authorization is necessary for any enforcement of Section 3. Ibid at Section 5. This argument does not withstand scrutiny. The Supreme Court has said that the 14th Amendment, quote, is undoubtedly self-executing without any ancillary legislation, so far as its terms are applicable to any existing state of circumstances, end quote. The Civil Rights Cases, 109 U.S. 3, 20, 1883. To be sure, in the civil rights cases, the court was directly focused on the 13th Amendment, so this statement could be described as dicta. But an examination of the 13th, 14th, and 15th Amendments, Reconstruction Amendments, and interpretation of them supports the accuracy and broader significance of the statement. Section 3 is one of 4 substantive sections of the 14th Amendment. Section 1, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, end quote. Section 2, quote, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, end quote. Section 3, quote, no person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office under the United States who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, end quote. Section 4, quote, the validity of the public debt of the United States shall not be questioned, end quote. U.S. Constitution, Amendment 14, Sections 1 to 4, emphases added. Section 5 is then an enforcement provision that applies to each of these substantive provisions, Ibid at Section 5, and yet the Supreme Court has held that Section 1 is self-executing, e.g., City of Bern v. Flores, 1997, quote, as enacted, the 14th Amendment confers substantive rights against the states which, like the provisions of the Bill of Rights, are self-executing, end quote. Thus, while Congress may enact enforcement legislation pursuant to Section 5, congressional action is not required to give effect to the constitutional provision. See Katzenbach v. Morgan, 1966, holding that Section 5 gives Congress authority to, quote, determine whether and what legislation is needed to secure the guarantees of the 14th Amendment, end quote, but not disputing that the 14th Amendment is self-executing. Section 2, moreover, was enacted to eliminate the constitutional compromise by which an enslaved person was counted as only 3/5 of a person for purposes of legislative apportionment. William Baude and Michael Stokes Paulson, The Sweep and Force of Section 3, forthcoming 2024. The self-executing nature of that section has never been called into question, and in the reapportionment following passage of the 14th Amendment, Congress simply treated the change as having occurred. See the Apportionment Act of 1872, 42nd Congress, apportioning representatives to the various states based on Section 2's command without mentioning or purporting to enforce the 14th Amendment. Similarly, Congress never passed enabling legislation to effectuate Section 4. The same is true for the 13th Amendment, which abolished slavery and involuntary servitude. Section 1 provides the substantive provision, quote, "Neither slavery nor involuntary servitude shall exist within the United States," end quote. U.S. Constitution, Amendment 13, Section 1, emphasis added. Section 2 provides the enforcement provision, quote, "Congress shall have power to enforce this article by appropriate legislation," end quote, ibid at Section 2. Discussing this amendment, the Supreme Court recognized that, quote, "Legislation may be necessary and proper to meet all the various cases and circumstances to be affected by it," end quote, but that, quote, "by its own unaided force it abolished slavery," end quote, and was, quote, "undoubtedly self-executing without any ancillary legislation," end quote. The Civil Rights Cases, 109 U.S. at 20. Like the other Reconstruction amendments, the 15th Amendment, which established universal male suffrage, contains a substantive provision, quote, "The right of citizens of the United States to vote shall not be denied or abridged on account of race, color, or previous condition of servitude," end quote, followed by an enforcement provision, quote, "The Congress shall have power to enforce this article by appropriate legislation," end quote. U.S. Constitution, Amendment 15, Sections 1 to 2, emphasis added. As with Section 1 of both the 13th and 14th Amendments, the Supreme Court has explicitly confirmed that the 15th Amendment is self-executing, e.g., South Carolina v. Katzenbach, 1966, holding that Section 1 of the 15th Amendment, quote, "has always been treated as self-executing and has repeatedly been construed, without further legislative specification, to invalidate state voting qualifications or procedures which are discriminatory on their face or in practice," end quote. There is no textual evidence that Congress intended Section 3 to be any different. Furthermore, we agree with the electors that interpreting any of the Reconstruction amendments, given their identical structure, as not self-executing would lead to absurd results. If these amendments required legislation to make them operative, then Congress could nullify them by simply not passing enacting legislation. The result of such an action would mean that slavery remains legal. Black citizens would be counted as less than full citizens for reapportionment. Non-white male voters could be disenfranchised, and any individual who engaged in insurrection against the government would nonetheless be able to serve in the government regardless of whether 2/3 of Congress had lifted the disqualification. Surely that was not the drafters' intent. Intervenors argue that certain historical evidence requires a different conclusion as to Section 3. We generally turn to historical and other extrinsic evidence only when the text is ambiguous, which it is not here. Nonetheless, we will consider these historical claims in the interest of providing a thorough review. Intervenors first highlight a statement Representative Thaddeus Stevens made during the congressional framing debates. Quote, "Section 3 will not execute itself, but as soon as it becomes a law, Congress at the next session will legislate to carry it out both in reference to the presidential and all other elections as we have the right to do." End quote. Congressional Globe, 39th Congress, First Session, 1866. See also Kurt T. Lash, The Meaning and Ambiguity of Section 3 of the 14th Amendment. October 3, 2023, unpublished manuscript. But as one of the amici points out, this statement referenced a deleted portion of Section 3 that disenfranchised all former Confederates until 1870. In any event, given the complex patchwork of perspectives and intentions expressed when drafting these constitutional provisions, we refuse to cherry-pick individual statements from extensive debates to ground our analysis. See generally Bode and Paulson, Supra. Intervenors next direct us to the non-binding opinion written by Chief Justice Salmon Chase while he was writing circuit. In Re. Griffin, 1869, Griffin's case. There, Caesar Griffin challenged his criminal conviction as null and void because, under Section 3, the judge who had entered his conviction was disqualified from holding judicial office, having formerly sworn a relevant oath as a state legislator and then engaged in insurrection by continuing to serve as a legislator in Virginia's Confederate government. It was undisputed that the judge fell within Section 3's scope. But the question Chief Justice Chase sought to answer was whether Section 3, quote, operated directly, without any intermediate proceeding whatever, upon all persons within the category of prohibition, and as depriving them at once and absolutely of all official authority and power, end quote. Ibid at 23. In interpreting the scope of the provision, Chief Justice Chase observed that after the end of the Civil War, but before the 14th Amendment was ratified, many Southern states had established, with the approval of the federal government, provisional governments to keep society functioning. And within these provisional governments, many offices were filled with citizens who would fall within Section 3's scope. Chief Justice Chase observed that giving Section 3 a literal construction, as Griffin advocated, would, quote, annul all official acts performed by these officers. No sentence, no judgment, no decree, no official act would be of the least validity, end quote. He reasoned that it would be, quote, impossible to measure the evils which such a construction would add to the calamities which have already fallen upon the people of these states, end quote. And so Chief Justice Chase turned to what he termed the, quote, argument from inconveniences, end quote, and the interpretive canon that, when faced with two or more reasonable interpretations, the interpretation, quote, is to be preferred which best harmonizes the amendment with the general terms and spirit of the act amended, end quote. He then explained that, while it was not, quote, improbable that one of the objects of this section was to provide for the security of the nation and of individuals by the exclusion of a class of citizens from office, end quote, it could also, quote, hardly be doubted that the main purpose was to inflict upon the leading and most influential characters who had been engaged in the rebellion exclusion from office as a punishment for the offense, end quote. To find the provision self-executing under the circumstances, he argued, would be contrary to due process because it would, quote, at once, without trial, deprive a whole class of persons of offices held by them, end quote. Chief Justice Chase therefore concluded that the object of the amendment, quote, to exclude from certain offices a certain class of persons, end quote, was impossible to do, quote, by a simple declaration, whether in the construction or in an act of Congress, for in the very nature of things it must be ascertained what particular individuals are embraced by the definition, before any sentence of exclusion can be made to operate, end quote. To accomplish, quote, this ascertainment and ensure effective results, proceedings, evidence, decisions, and enforcement of decisions are indispensable and can only be provided for by Congress, end quote. Thus, Chief Justice Chase concluded that Section 3 was not self-executing. Griffin's case concludes that congressional action is needed before Section 3 disqualification attaches, but this one case does not persuade us of that point. Interveners and amici assert that Griffin's case, quote, remains good law and has been repeatedly relied on, end quote. Because the case is not binding on us, the fact that it has not been reversed is of no particular significance, and the cases that cite it do so either with no analysis, e.g. State v. Buckley, 1875, and Rothermel v. Meyerly, 1890, or for the inopposite proposition that Section 3 does not create a self-executing cause of action, e.g. Cale v. City of Covington, 1978, and Hansen v. Fenton, 2022, affirmed on other grounds. Moreover, Griffin's case has been the subject of persuasive criticism. See E.G. Maglioka, Amnesty and Section 3, Supra, at 105 to 108, critiquing the case because the other provisions of the 14th Amendment were understood as self-executing, and the notion that Section 3 was not self-executing was inconsistent with congressional behavior at the time. Bowden Paulson, Supra, criticizing Chief Justice Chase's interpretation as wrong and constituting a strained interpretation based on policy and circumstances rather than established canons of construction. Although we do not find Griffin's case compelling, we agree with Chief Justice Chase that, quote, it must be ascertained what particular individuals are embraced by the definition, end quote. While the disqualification of Section 3 attaches automatically, the determination that such an attachment has occurred must be made before the disqualification holds meaning. And Congress has the power under Section 5 to establish a process for making that determination. But the fact that Congress may establish such a process does not mean that disqualification pursuant to Section 3 can be determined only through a process established by Congress. Here, the Colorado legislature has established a process, a court proceeding pursuant to Section 11113, to make the determination whether a candidate is qualified to be placed on the presidential primary ballot. And, for the reasons we have already explained, that process is sufficient to permit a judicial determination of whether Section 3 disqualification has attached to a particular individual. We are similarly unpersuaded by interveners' assertions that Congress created the only currently available mechanism for determining whether a person is disqualified pursuant to Section 3, with the 1994 passage of 18 U.S.C. Section 2383. That statute makes it a crime to, quote, assist or engage in any rebellion or insurrection against the authority of the United States, end quote. True, with that enactment, Congress criminalized the same conduct that is disqualifying under Section 3. All that means, however, is that a person charged and convicted under 18 U.S.C. 2383 would also be disqualified under Section 3. It cannot be read to mean that only those charged and convicted of violating that law are constitutionally disqualified from holding future office, without assuming a great deal of meaning not present in the text of the law. In summary, based on Section 3's plain language, Supreme Court decisions declaring its neighboring, parallel Reconstruction amendments self-executing, and the absurd results that would flow from interveners' reading, we conclude that Section 3 is self-executing in the sense that its disqualification provision attaches without congressional action. Interveners' contrary arguments do not persuade us otherwise. That said, our conclusion that implementing legislation from Congress is unnecessary for us to proceed under Section 11113 does not resolve the question of whether doing so would violate the separation of powers among the three branches of government. We turn to this justiciability question next. D. Section 3 is justiciable. President Trump next asserts that presidential disqualification under Section 3 presents a non-justiciable political question. Again, we disagree. Quote, in general, the judiciary has a responsibility to decide cases properly before it, even those it would gladly avoid, end quote. Zivotofsky, quoting Cohens v. Virginia, 1821. The political question doctrine is a very narrow exception to this rule, and a court may not avoid its responsibility to decide a case merely because it may have political implications. A controversy involves a non-justiciable political question when, as relevant here, quote, there is a textually demonstrable constitutional commitment of the issue to a coordinate political department, or a lack of judicially discoverable and manageable standards for resolving it, end quote. Ibid, quoting Nixon v. United States, 1993. See also Baker v. Carr, 1962, noting that, quote, the non-justiciability of a political question is primarily a function of the separation of powers, end quote, and identifying the above described instances, and four others not relevant here, as examples of political questions. The requisite textual commitment must be, quote, prominent on the surface of any case, end quote. Baker. Here, President Trump argues that this case is non-justiciable because, in his view, the Constitution and federal law commit the question of the qualifications of a presidential candidate to Congress. The electors point out that President Trump did not argue before us that the questions presented in this appeal are also non-justiciable based on a lack of judicially discoverable and manageable standards, and therefore he arguably waived any such argument. We nevertheless address that issue again in the interest of providing a thorough review. 1. No textually demonstrable constitutional commitment to Congress of Section 3 disqualification. Contrary to President Trump's assertions, we perceive no constitutional provision that reflects a textually demonstrable commitment to Congress of the authority to assess presidential candidate qualifications. Conversely, the Constitution commits certain authority concerning presidential elections to the states, and in no way precludes the states from exercising authority to assess the qualifications of presidential candidates. As discussed in Part B-4 above, Article 2, Section 1, Clause 2 of the Constitution empowers state legislatures to direct how presidential electors are appointed, and the Supreme Court has recognized that this provision affords the states, quote, far-reaching authority over presidential electors absent some other constitutional constraint, end quote. Chiafalo. In furtherance of this delegation of authority, quote, the states have evolved comprehensive and in many respects complex election codes regulating in most substantial ways, with respect to both federal and state elections, end quote, the, quote, selection and qualification of candidates, end quote, among other things. Storer. The election code is an example of such a comprehensive code to regulate state and federal elections. And the fact that Article 2, Section 1, Clause 4 authorizes Congress to determine the time for choosing the electors and the date on which they vote does not undermine the substantial authority provided to the states to regulate state and federal elections. In our view, Section 3's text is fully consistent with our conclusion that the Constitution has not committed the matter of presidential candidate qualifications to Congress. As we have noted, although Section 3 requires a vote of 2/3 of each House to remove the disqualification set forth in Section 3, it says nothing about who or which branch should determine disqualification in the first place. See U.S. Constitution Amendment 14, Section 3. Moreover, if Congress were authorized to decide by a simple majority that a candidate is qualified under Section 3, as President Trump asserts, then this would nullify Section 3's supermajority requirement. President Trump's reliance on Article 2, Section 1, Clause 5 of the Constitution and on the 12th, 14th, and 20th Amendments is misplaced. We address each of these provisions in turn. Article 2, Section 1, Clause 5 provides that no person shall be eligible to serve as president unless that person is a natural-born citizen who is at least 35 years of age and who has resided in the United States for at least 14 years. This provision, however, says nothing about who or which branch should determine whether a candidate satisfies the qualification criteria, either in the first instance or when a candidate's qualifications are challenged. See Ibid. The 12th Amendment charges the Electoral College with the task of selecting a candidate for president and then transmitting the electors' votes to the seat of the government of the United States, and it provides the procedure by which the electoral votes are to be counted. U.S. Constitution, Amendment 12. Nothing in the 12th Amendment, however, vests the Electoral College with the power to determine the eligibility of a presidential candidate. See Elliott v. Cruz, 2016, affirmed 2016. Nor does the 12th Amendment give Congress, quote, control over the process by which the president and vice president are normally chosen, other than the very limited one of determining the day on which the electors were to give their votes, end quote. Ibid, citing U.S. Constitution Amendment 12. And although the 12th Amendment provides for the scenario in which no president is selected by March 4th, and specifies that no person constitutionally ineligible to serve as president shall be eligible to serve as vice president, the amendment does not assign to Congress, nor to any other branch, the task of determining whether a candidate is qualified in the first place. Section 5 of the 14th Amendment authorizes Congress to pass legislation to enforce the provisions of the 14th Amendment, but as discussed above, the 14th Amendment is self-executing, and congressional action under Section 5 is not required to animate Section 3's disqualification of insurrectionist oath-breakers. Nor does Section 5 delegate to Congress the authority to determine the qualifications of presidential candidates to hold office. U.S. Constitution, Amendment 14, Section 5. Finally, the 20th Amendment, in relevant part, empowers Congress to enact procedures to address the scenario in which neither the President nor the Vice President qualifies for office before the time fixed for the beginning of their terms. U.S. Constitution, Amendment 20, Section 3. By its express language, however, this amendment applies post-election. Ibid, referring to the President-elect and Vice President-elect. Moreover, the amendment says nothing about who determines in the first instance whether the President and Vice President are qualified to hold office. For these reasons, we perceive no textually demonstrable constitutional commitment to Congress of the authority to assess presidential candidate qualifications, and neither President Trump nor his amici identify any constitutional provision making such a commitment. In reaching this conclusion, we are unpersuaded by the cases on which President Trump and his amici rely, which are predicated on inferences they assert can be drawn from one or more of the foregoing constitutional provisions, or on the fact that the cases had political implications. As noted above, such inferences are insufficient to establish the requisite clear textual commitment to a coordinate branch of government, and we may not avoid our duty to decide a case merely because it may have political implications. Moreover, we may not conflate, quote, actions that are textually committed, end quote, to a coordinate political branch with, quote, actions that are textually authorized, end quote. Stillman v. Department of Defense, 2002, reversed on other grounds, subnom Stillman v. CIA, D.C. Circuit, 2003. The Supreme Court has prohibited courts from adjudicating only the former. Absent an affirmative constitutional commitment, we cannot abdicate our responsibility to decide a case that is properly before us. 2. Section 3 involves judicially discoverable and manageable standards. The question of whether there are judicially discoverable and manageable standards for determining a case is not wholly separate from the question of whether the matter has been textually committed to a coordinate political department. United States v. Nixon, quote, the lack of judicially manageable standards may strengthen the conclusion that there is a textually demonstrable commitment to a coordinate branch, end quote. Ibid. As we have said, President Trump has not argued before us that Section 3 lacks judicially discoverable and manageable standards, and we believe for good reason. Section 3 disqualifies from certain delineated offices persons who have, quote, taken an oath to support the Constitution of the United States, end quote, as an, quote, officer of the United States, end quote, and who have thereafter, quote, engaged in insurrection or rebellion, end quote. U.S. Constitution, Amendment 14, Section 3. Although, as we discuss below, the meanings of some of these terms may not necessarily be precise, we can discern their meanings using familiar principles of constitutional interpretation, such as careful examination of the textual, structural, and historical evidence put forward by the parties. Indeed, in this and other contexts, courts have readily interpreted the terms that we are being asked to construe and have reached the substantive merits of the cases before them. See, e.g., United States v. Powell, 1871, defining engage as that term is used in Section 3, United States v. Rhine, 2023, defining insurrection in the context of ruling on a motion in limine in a criminal prosecution arising out of the events of January 6th, Holiday Inns, Inc. v. Aetna Insurance Company, 1983, defining insurrection in the context of an insurance policy exclusion, Gitlow v. Kiley, defining insurrection as that term is used in a section of the U.S. Code, Huron v. Callis, 1935, defining insurrection as that term is used in a provision of the South Carolina Constitution. Accordingly, we conclude that interpreting Section 3 does not, quote, turn on standards that defy judicial application, Zivotofsky, quoting Baker. In so concluding, we respectfully disagree with the Michigan Court of Claims finding that the interpretation of the terms now before us constitutes a non-justiciable political question merely because, quote, there are many answers and gradations of answers, end quote. Trump v. Benson, 2023. In our view, declining to decide an issue simply because it requires us to address difficult and weighty questions of constitutional interpretation would create a slippery slope that could lead to a prohibited dereliction of our constitutional duty to adjudicate cases that are properly before us. For these reasons, we conclude that the issues presented here do not, either alone or together, constitute a non-justiciable political question. We thus proceed to the question of whether Section 3 applies to the President. E. Section 3 applies to the President. The parties debate the scope of Section 3. The electors claim that this potential source of disqualification encompasses the President. President Trump argues that it does not, and the District Court agreed. On this issue, we reverse the District Court. Section 3 prohibits a person from holding any, quote, office, civil or military, under the United States, end quote, if that person as, quote, an officer of the United States, end quote, took an oath, quote, to support the Constitution of the United States, end quote, and subsequently engaged in insurrection. U.S. Constitution Amendment 14, Section 3. Accordingly, Section 3 applies to President Trump only if 1. The presidency is an, quote, office, civil or military, under the United States, end quote. 2. The president is an, quote, officer of the United States, end quote. And 3. The presidential oath set forth in Article 2 constitutes an oath, quote, to support the Constitution of the United States, end quote. Ibid. We address each point in turn. 1. The presidency is an office under the United States. The District Court concluded that the presidency is not an, quote, office, civil or military, under the United States, end quote, for 2 reasons. Anderson, see U.S. Constitution Amendment 14, Section 3. First, the court noted that the presidency is not specifically mentioned in Section 3, though senators, representatives, and presidential electors are. The court found it unlikely that the presidency would be included in a catch-all of, quote, any office, civil or military, end quote. Second, the court found it compelling that an earlier draft of the section specifically included the presidency, suggesting that the drafters intended to omit the presidency in the version that passed. We disagree with the district court's conclusion, as our reading of both the constitutional text and the historical record counsel that the presidency is an office under the United States within the meaning of Section 3. When interpreting the Constitution, we prefer a phrase's normal and ordinary usage over, quote, secret or technical meanings that would not have been known to ordinary citizens in the founding generation, end quote. District of Columbia v. Heller, 2008. Dictionaries from the time of the 14th Amendment's ratification define office as a, quote, particular duty, charge, or trust conferred by public authority and for a public purpose, end quote, that is, quote, undertaken by authority from government or those who administer it, end quote. Noah Webster, An American Dictionary of the English Language, 689. Chauncey A. Goodrich edition, 1853. See also 5 Johnson's English Dictionary 646, J.E. Worcester edition, 1859. Defining office as, quote, a public charge or employment, magistracy, end quote. United States v. Maurice, 1823, quote, an office is defined to be a public charge or employment, end quote. The presidency falls comfortably within these definitions. We do not place the same weight the district court did on the fact that the presidency is not specifically mentioned in Section 3. It seems most likely that the presidency is not specifically included because it is so evidently an office. In fact, no specific office is listed in Section 3. Instead, the section refers to any office, civil or military. U.S. Constitution, Amendment 14, Section 3. True, senators, representatives, and presidential electors are listed, but none of these positions is considered an office in the Constitution. Instead, senators and representatives are referred to as members of their respective bodies. See U.S. Constitution, Article 1, Section 5, Clause 1. Quote, each house shall be the judge of the elections, returns, and qualifications of its own members, end quote. Ibid at Section 6, Clause 2, quote, no person holding any office under the United States shall be a member of either house during his continuance in office, end quote. Ibid at Article 2, Section 1, Clause 2, quote, no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector, end quote. Indeed, even interveners do not deny that the presidency is an office. Instead, they assert that it is not an office under the United States. Their claim is that the President and elected members of Congress are the government of the United States and cannot therefore be serving under the United States. We cannot accept this interpretation. A conclusion that the presidency is something other than an office under the United States is fundamentally at odds with the idea that all government officials, including the president, serve we the people. Ibid at preamble. A more plausible reading of the phrase under the United States is that the drafters meant simply to distinguish those holding federal office from those held under any state. Ibid at Amendment 14, Section 3. This reading of the language of Section 3 is, moreover, most consistent with the Constitution as a whole. The Constitution refers to the presidency as an office 25 times, e.g., Ibid at Article 1, Section 3, Clause 5, quote, the Senate shall choose their other officers and also a president pro tempore in the absence of the vice president or when he shall exercise the office of President of the United States, end quote. Emphasis added. Ibid at Article 2, Section 1, Clause 5, providing that, quote, no person except a natural-born citizen shall be eligible to the office of President, end quote, and, quote, the executive power shall be vested in a President of the United States of America who shall hold his office during the term of 4 years, end quote, emphases added. And it refers to an office under the United States in several contexts that clearly support the conclusion that the presidency is such an office. Consider, for example, the impeachment clause, which reads that Congress can impose, as a consequence of impeachment, a, quote, disqualification to hold and enjoy any office of honor, trust, or profit under the United States, end quote. Ibid at Article 1, Section 3, Clause 7. If the presidency is not an office under the United States, then anyone impeached, including a president, could nonetheless go on to serve as president. See Ibid. This reading is nonsensical, as recent impeachments demonstrate. The articles of impeachment brought against both President Clinton and President Trump asked for each man's, quote, removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, end quote. Articles of impeachment against William Jefferson Clinton, House Resolution 611, 105th Congress, December 19, 1998. See also Articles of Impeachment against Donald J. Trump, House Resolution 755, 116th Congress, December 8, 2019. Articles of Impeachment against Donald J. Trump, House Resolution 24, 117th Congress, January 13, 2021. Surely the impeaching members of Congress correctly understood that either man, if convicted and subsequently disqualified from future federal office by the Senate, would be unable to hold the presidency in the future. Similarly, the incompatibility clause states that, quote, no person holding any office under the United States shall be a member of either house during his continuance in office, end quote. U.S. Constitution, Article 1, Section 6, Clause 2. To read office under the United States to exclude the presidency would mean that a sitting president could also constitutionally occupy a seat in Congress, a result foreclosed by basic principles of the separation of powers. See Buckley v. Vallejo, 1976, quote, the principle of separation of powers was woven into the Constitution. The further concern of the framers of the Constitution with maintenance of the separation of powers is found in the so-called ineligibility and incompatibility clauses contained in Article 1, Section 6, end quote, superseded by statute on other grounds Bipartisan Campaign Reform Act of 2002, as recognized in McConnell v. Federal Election Commission, 2003, overruled on other grounds by Citizens United v. Federal Election Commission, 2010. Finally, the Emoluments Clause provides that, quote, no person holding any office of profit or trust under the United States shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state, end quote. U.S. Constitution, Article 1, Section 9, Clause 8. To read the presidency as something other than an office under the United States would exempt the nation's chief diplomat from these protections against foreign influence. But presidents have long sought dispensation from Congress to retain gifts from foreign leaders, understanding that the Emoluments Clause required them to do so. The district court found it compelling that an earlier draft of the proposed section listed the presidency, but the version ultimately passed did not. As a starting point, however, we are mindful that, quote, it is always perilous to derive the meaning of an adopted provision from another provision deleted in the drafting process, end quote. Heller. And the specifics of the change of the earlier draft to what was ultimately passed do not demonstrate an intent to exclude the presidency from the covered offices. The draft proposal provided that insurrectionist oath-breakers could not hold, quote, the office of President or Vice President of the United States, Senator or Representative in the National Congress, or any office now held under appointment from the President of the United States and requiring the confirmation of the Senate, end quote. Congressional Globe, 39th Congress, First Session, 919, 1866, emphasis added. Later versions of the section, including the enacted draft, removed specific reference to the President and Vice President and expanded the category of office holder to include, quote, any office, civil or military, end quote, rather than only those offices requiring presidential appointment and Senate confirmation. See U.S. Constitution, Amendment 14, Section 3. It is hard to glean from the limited available evidence what the changes across proposals meant. But we find persuasive amici's suggestion that Representative McKee, who drafted these proposals, most likely took for granted that his second proposal included the president. While nothing in Representative McKee's speeches mentions why his express reference to the presidency was removed, his public pronouncements leave no doubt that his subsequent draft proposal still sought to ensure that rebels had absolutely no access to political power. Representative McKee explained that, under the proposed amendment, quote, the loyal alone shall rule the country, end quote, and that traitors would be, quote, cut off from all political power in the nation, end quote. Congressional Globe, 39th Congress, First Session, 1866. See also Mark Graber, Section 3 of the 14th Amendment, Our Questions, Their Answers. University of Maryland Legal Studies Research Paper number 2023-16. Mark A. Graber, Punish Treason, Reward Loyalty, The Forgotten Goals of Constitutional Reform After the Civil War, 2023, indicating that Representative McKee desired to exclude all oath-breaking insurrectionists from all federal offices, including the presidency. When considered in light of these pronouncements, the shift from specifically naming the president and vice president in addition to officers appointed and confirmed to the broadly inclusive any officer, civil or military, cannot be read to mean that the two highest offices in the government are excluded from the mandate of Section 3. The importance of the inclusive language, any officer, civil or military, was the subject of a colloquy in the debates around adopting the 14th Amendment. Senator Reverdy Johnson worried that the final version of Section 3 did not include the office of the presidency. He stated, quote, "This amendment does not go far enough," end quote, because past rebels, quote, "may be elected President or Vice President of the United States," end quote. Congressional Globe, 39th Congress, First Session, 1866. So, he asked, quote, "Why did you omit to exclude them?" "I do not understand them to be excluded from the privilege of holding the two highest offices in the gift of the nation," end quote. Ibid. Senator Lot Morrill fielded this objection. He replied, quote, "Let me call the senator's attention to the words, 'or hold any office, civil or military, under the United States,'" end quote. Ibid. This answer satisfied Senator Johnson, who stated, quote, "Perhaps I am wrong as to the exclusion of the presidency. No doubt I am, but I was misled by noticing the specific exclusion in the case of senators and representatives," end quote. Ibid. This colloquy further supports the view that the drafters of this amendment intended the phrase "any office" to be broadly inclusive and certainly to include the presidency. Moreover, Reconstruction-era citizens, supporters and opponents of Section 3 alike, understood that Section 3 disqualified oath-breaking insurrectionists from holding the office of the president. See Montpelier Daily Journal, October 19, 1868, writing that Section 3, quote, "excludes leading rebels from holding offices from the presidency downward," end quote. Many supporters of Section 3 defended the amendment on the ground that it would exclude Jefferson Davis from the presidency. See John Vlahopoulos, Insurrection, Disqualification, and the Presidency, American Legal Studies, forthcoming 2023. See also, e.g., Rebels and Federal Officers, Gallipolis J., February 21, 1867, at 2, arguing that foregoing Section 3 would, quote, "render Jefferson Davis eligible to the presidency of the United States," end quote, and, quote, "there is something revolting in the very thought," end quote. Post-ratification history includes more of the same. For example, Congress floated the idea of blanket amnesty to shield rebels from Section 3. See Vlahopoulos Supra. In response, both supporters and dissenters acknowledged that doing so would allow the likes of Jefferson Davis access to the presidency. See Ibid. See also, e.g., the Pulaski Citizen, the New Reconstruction Bill, April 13, 1871, at 4, acknowledging as a supporter of amnesty that it would, quote, "make even Jefferson Davis eligible again to the presidency," end quote. The Chicago Tribune, May 24, 1872, asserting that amnesty would make rebels, quote, "eligible to the presidency of the United States," end quote. Indiana Progress, August 24, 1871, similar. We conclude, therefore, that the plain language of Section 3, which provides that no disqualified person shall, quote, "hold any office, civil or military, under the United States," end quote, includes the office of the presidency. This textual interpretation is bolstered by constitutional context and by history surrounding the enactment of the 14th Amendment. 2. The President is an officer of the United States. We next consider whether a president is an officer of the United States. U.S. Constitution, Amendment 14, Section 3. The District Court found that the drafters of Section 3 did not intend to include the President within the catch-all phrase, officer of the United States, and accordingly, that a current or former president can engage in insurrection and then run for and hold any office. We disagree for 4 reasons. First, the normal and ordinary usage of the term officer of the United States includes the President. As we have explained, the plain meaning of office under the United States includes the presidency. It follows then that the President is an officer of the United States. See Motions Systems Corp. v. Bush, 2006. Garjasa J. concurring in part, quote, an interpretation of the Constitution in which the holder of an office is not an officer seems, at best, strained, end quote. Indeed, Americans have referred to the President as an officer from the days of the founding. See, e.g., The Federalist, number 69, Alexander Hamilton, quote, the President of the United States would be an officer elected by the people, end quote. And many 19th century presidents were described as, or called themselves, quote, Chief Executive Officer of the United States, end quote. Second, Section 3's drafters and their contemporaries understood the President as an officer of the United States. See Graeber, Our Questions, Their Answers. See also Congressional Globe, 39th Congress, First Session, 1866, referring to the Chief Executive Officer of the country. The Floyd Acceptances, 1868. Quote, we have no officers in this government from the President down to the most subordinate agent who does not hold office under the law with prescribed duties and limited authority, end quote. Emphases added. President Trump concedes as much on appeal, stating that, quote, to be sure, the President is an officer, end quote. He argues, however, that the President is an officer of the Constitution, not an officer of the United States, which he posits is a constitutional term of art. Further, at least one amicus contends that the above-referenced historical uses referred to the President as an officer only in a colloquial sense and thus have no bearing on the term's use in Section 3. We disagree. The informality of these uses is exactly the point. If members of the 39th Congress and their contemporaries all used the term officer according to its ordinary meaning to refer to the President, we presume this is the same meaning the drafters intended it to have in Section 3. We perceive no persuasive contemporary evidence demonstrating some other technical term of art meaning, and in the absence of a clear intent to employ a technical definition for a common word, we will not do so. See Heller, explaining that the, quote, normal and ordinary as distinguished from technical meaning, end quote, should be favored, quoting United States v. Sprague, 1931. We also find Attorney General Stanberry's opinions on the meaning of Section 3 significant. In one opinion on the subject, Stanberry explained that the term, quote, officer of the United States within Section 3 is used in its most general sense and without any qualification as legislative or executive or judicial, end quote. The Reconstruction Acts, 1867. And in a second opinion on the topic, he observed that the term, quote, officers of the United States, end quote, includes, without limitation, any, quote, person who has at any time prior to the rebellion held any office, civil or military, under the United States and has taken an official oath to support the Constitution of the United States, end quote. The Reconstruction Acts, 1867. Third, the structure of Section 3 persuades us that the President is an officer of the United States. The first half of Section 3 describes the offices protected, and the second half addresses the parties barred from holding those protected offices. There is a parallel structure between the two halves. Senator or representative in Congress, protected office, corresponds to member of Congress, barred party. Any office under the United States, protected office, corresponds to officer of the United States, barred party, and Any office under any state protected office also has a corresponding barred party in member of any state legislature or as an executive or judicial officer of any state. U.S. Constitution, Amendment 14, Section 3. The only term in the first half of Section 3 that has no corresponding officer or party in the second half is elector of president and vice president, which makes sense because electors do not take constitutionally mandated oaths, so they have no corresponding barred party. Ibid. See also Ibid at Article 2, Section 1, discussing a presidential elector's duties without reference to an oath. Ibid at Article 6, excluding presidential electors from the list of positions constitutionally obligated to take an oath to support the Constitution. Save electors. There is a perfect parallel structure in Section 3. See Bode and Paulson, Supra. Fourth, the clear purpose of Section 3, to ensure that disloyal officers could never again play a role in governing the country, leaves no room to conclude that officer of the United States was used as a term of art. Ibid. The drafters of Section 3 were motivated by a sense of betrayal, that is, by the existence of a broken oath, not by the type of officer who broke it. Quote, "All of us understand the meaning of the third section," end quote, Senator John Sherman stated. Quote, "It includes those men who have once taken an oath of office to support the Constitution of the United States and have violated that oath in spirit by taking up arms against the government of the United States are to be deprived for a time at least of holding office." End quote. Congressional Globe, 39th Congress, First Session, 1866. See also Ibid at 2898. Senator Thomas Hendricks of Indiana, who opposed the 14th Amendment, agreeing that the theory of Section 3 was, quote, that persons who have violated the oath to support the Constitution of the United States ought not to be allowed to hold any office, end quote. Ibid. Senator John B. Henderson explaining that, quote, the language of this section is so framed as to disenfranchise from office the leaders of any rebellion hereafter to come. Powell, summarizing the purpose of Section 3, quote, those who had once been trusted to support the power of the United States and proved false to the trust reposed ought not, as a class, to be entrusted with power again until Congress saw fit to relieve them from disability, end quote. A construction of Section 3 that would nevertheless allow a former president who broke his oath not only to participate in the government again, but to run for and hold the highest office in the land is flatly unfaithful to the section's purpose. We therefore conclude that officer of the United States, as used in Section 3, includes the President. 3. The presidential oath is an oath to support the Constitution. Finally, we consider whether the oath taken by the President to, quote, preserve, protect, and defend the Constitution, end quote, U.S. Constitution, Article 2, Section 1, Clause 8, is an oath, quote, to support the Constitution of the United States, end quote, Ibid at Amendment 14, Section 3. The District Court found that, because the presidential oath's language is more particular than the oath referenced in Section 3, the drafters did not intend to include former presidents. We disagree. Article 6 of the Constitution provides that, quote, all executive and judicial officers of the United States shall be bound by oath or affirmation to support this Constitution, end quote. U.S. Constitution, Article 6, Clause 3. Article 2 specifies that the President shall swear an oath to, quote, preserve, protect, and defend the Constitution, end quote, Ibid at Article 2, Section 1, Clause 8. Interveners contend that because the Article 2 oath does not include a pledge to support the Constitution, an insurrectionist president cannot be disqualified from holding future office under Section 3 on the basis of that oath. This argument fails because the President is an executive officer of the United States under Article 6, albeit one for whom a more specific oath is prescribed. Ibid at Article 6, Clause 3, quote, "The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution." End quote. This conclusion follows logically from the accepted fact that the Vice President is also an executive officer. True, the Vice President takes the more general oath prescribed by federal law, see 5 U.S.C. Section 3331, noting that anyone, quote, "except the President, elected or appointed to an office of honor or profit in the civil service or uniformed services shall take," end quote, an oath including a pledge to, quote, "support and defend the Constitution," end quote. But it makes no sense to conclude that the Vice President is an executive officer under Article 6, but the President is not. The language of the presidential oath, a commitment to, quote, "preserve, protect, and defend the Constitution," end quote, is consistent with the plain meaning of the word support. U.S. Constitution, Article 2, Section 1, Clause 8. Modern dictionaries define support to include defend and vice versa. See e.g. support, Merriam-Webster Dictionary, defining support as to uphold or defend as valid or right. See also defend at Ibid, defining defend as to maintain or support in the face of argument or hostile criticism. So did dictionaries from the time of Section 3's drafting. See e.g. Samuel Johnson, A Dictionary of the English Language, 5th edition, 1773. Defend, to stand in defense of, to protect, to support. Noah Webster, An American Dictionary of the English Language, 271, Chauncey A. Goodrich edition, 1857. Defend, to support or maintain. The specific language of the presidential oath does not make it anything other than an oath to support the Constitution. Indeed, as one senator explained just a few years before Section 3's ratification, quote, "The language in the presidential oath of office, that he shall protect, support, and defend the Constitution, makes his obligation more emphatic and more obligatory, if possible, than ours, which is simply to support the Constitution." End quote. Congressional Globe, 37th Congress, 3rd Session, 1862. And, in fact, several 19th century presidents referred to the presidential oath as an oath to support the Constitution. See James D. Richardson, A Compilation of the Messages and Papers of the Presidents, 1789 to 1897, Volume 1 at 232, 467, Adams, Madison, Volume 2 at 625, Jackson, Volume 8 at 381, Cleveland. In sum, quote, "The simplest and most obvious interpretation of a Constitution, if in itself sensible, is the most likely to be that meant by the people in its adoption." End quote. Lake County v. Rollins, 1889. The most obvious and sensible reading of Section 3, supported by text and history, leads us to conclude that 1. The presidency is an office under the United States. 2. The president is an officer of the United States. And 3. The presidential oath under Article 2 is an oath to support the Constitution. President Trump asks us to hold that Section 3 disqualifies every oath-breaking insurrectionist except the most powerful one, and that it bars oath-breakers from virtually every office, both state and federal, except the highest one in the land. Both results are inconsistent with the plain language and history of Section 3. We therefore reverse the district court's finding that Section 3 does not apply to a president and conclude that Section 3 bars President Trump from holding the office of the president if its other provisions are met, namely, if President Trump, quote, "engaged in insurrection," end quote. U.S. Constitution Amendment 14, Section 3. Before addressing the district court's findings that President Trump engaged in insurrection, however, we considered President Trump's challenge to the admissibility of a congressional report on which the district court premised some of its findings. F. The district court did not err in admitting portions of the January 6th report. President Trump asserts that the district court wrongly admitted into evidence 31 findings from a congressional report drafted by the Select Committee to investigate the January 6th attack on the U.S. Capitol. The committee, which recounted the committee's investigation of the facts, circumstances, and causes of the attack on the Capitol. See House Resolution Report Number 117663, December 22, 2022. The report. In President Trump's view, the report is an untrustworthy, partisan political document and therefore constituted inadmissible hearsay under Rule 803(8)(c) of the Colorado Rules of Evidence. We are unpersuaded. Under the deferential standard of review that governs, we perceive no error by the district court in admitting portions of the report into evidence at trial. We review a district court's evidentiary rulings for an abuse of discretion. Zaputa v. People, 2018, Colorado 82. Quote, "A court abuses its discretion only if its decision is manifestly arbitrary, unreasonable, or unfair." End quote. Churchill v. University of Colorado at Boulder, 2012, Colorado 54, quoting Freedom Colorado Info, Inc. v. El Paso County Sheriff's Department, Colorado 2008. We may not consider, quote, whether we would have reached a different result, end quote, but only, quote, whether the trial court's decision fell within a range of reasonable options, end quote. Ibid, quoting E470 publication Highway Auth v. Revenig, Colorado Appeals, 2006. Hearsay statements are out-of-court statements offered in court for the truth of the matter asserted. Such statements are generally inadmissible, but CRE 803(8) creates an exception for, quote, reports of public offices or agencies setting forth factual findings resulting from an investigation made pursuant to authority granted by law, end quote. This exception, however, applies only if the report is trustworthy. Ibid. The federal rules of evidence, on which our evidentiary rules were modeled, contain a near-identical exception to Colorado Rule 803(8). See Federal Rules of Evidence 803(8). So we may look to federal case law interpreting the federal rule for guidance on how to assess trustworthiness. See Garcia v. Schneider Energy Services, Inc., 2012, Colorado 62, noting that, although we are, quote, not bound to interpret our rules the same way the United States Supreme Court has interpreted its rules, we do look to the federal rules and federal decisions interpreting those rules for guidance, end quote. Harding Glass Company v. Jones, Colorado, 1982, quote, case law interpreting the federal rule is persuasive in analysis of the Colorado rule, end quote. Under federal law, courts are instructed to, quote, assume admissibility in the first instance, end quote. Beech Aircraft Corporation v. Rainey, 1988. Thus, quote, the party challenging the admissibility of a public or agency report bears the burden of demonstrating that the report is not trustworthy, end quote. Berry v. Trustees of International Association, 2006. The federal courts have also identified 4 non-exclusive factors to help courts determine trustworthiness. Quote, 1. The timeliness of the investigation. 2. The special skill or expertise of the investigating official. 3. Whether a hearing was held and the level at which it was conducted. And 4. Possible motivation problems, end quote. Ibid at 97. See Beech Aircraft. The district court employed the foregoing presumption and 4 factors to analyze the report. The court determined that, quote, the first 3 Berry factors weigh strongly in favor of reliability, end quote. President Trump focuses his admissibility challenge on the 4th factor, possible motivation problems. First, President Trump claims the report was biased against him because all 9 committee members voted in favor of impeaching him before their investigation began. Timothy Heaphy, chief investigative counsel for the committee, testified at trial, however, that although members, quote, certainly had hypotheses that were a starting point, end quote, such hypotheses did not impair the members' ability to be fair and impartial. The district court found, quote, Mr. Heafy's testimony on this subject to be credible and held that any perceived animus of the committee members towards President Trump did not taint the conclusions of the January 6th report in such a way that would render them unreliable." End quote. Ibid. We see no abuse of discretion. See People v. Pitts, Colorado 2000. Quote, "It is the function of the trial court and not the reviewing court to weigh evidence and determine the credibility of the witnesses." End quote. Second, President Trump believes that the political backdrop against which the report was created makes it unreliable. This argument proves too much. All congressional reports contain some level of political motivation, yet neither CRA 8038 nor the corresponding federal rule declare such reports per se inadmissible. Instead, as the district court explained, a court is at liberty to admit what it deems trustworthy. C. Anderson, paragraph 28. C. E. G. Berry, admitting report from a Senate investigation. Mariani v. United States, 1999, admitting minority report from a congressional investigation. Hobson v. Wilson, DDC 1982, admitting congressional committee report. Affirmed in part, reversed in part, D.C. Circuit 1984. Third, President Trump asserts that because Democrats outnumbered Republicans 7-2 on the committee, the report's findings are necessarily biased. The district court determined that although the report, quote, "would have further reliability had there been greater Republican participation," end quote, that deficit did not demonstrate motivation problems. The district court observed that House Republicans opted to boycott the committee after then-Speaker of the House Nancy Pelosi agreed to seat only 3 of the 5 Republicans recommended to her. Despite then-Speaker Pelosi's unprecedented move, the district court noted that, quote, "the 2 Republicans who did sit were both duly elected Republicans," end quote. Quote, "the investigative staff included many Republican," end quote, lawyers. Quote, "the staffing decisions did not include any inquiry into political affiliation," end quote, and, quote, "the overwhelming majority of witnesses were President Trump administration officials and Republicans," end quote. The court reasoned that, quote, "these facts all cut against interveners' argument that lack of participation of the minority party resulted in unreliable conclusions," end quote. Again, we perceive no abuse of discretion. CRA 8038 assumes admissibility, and President Trump has not met his burden of demonstrating that, contrary to the evidence the district court highlighted, the report suffered from motivation problems. Moreover, we remain mindful that this is a 4-factor inquiry. No single factor is dispositive. Instead, any perceived shortcomings as to one must be weighed against the strengths of the others. Whatever the possible motivation problems, the weight of the other 3 factors remains. As the district court explained, 1. Passage of time does not impugn the report, as the investigation began 6 months after the attack and was completed in under 2 years. 2. The investigative staff consisted of highly skilled lawyers, including 2 former U.S. attorneys, and 3. There was a formal 10-day hearing in which 70 witnesses testified under oath. So, not only was the court's analysis of the 4th factor reasonable, but it also did not abuse its discretion in reaching its broader conclusion that the report was trustworthy. President Trump nonetheless argues that even if the report is generally admissible under the CRE 8038 exception, there were 11 admitted findings within the report that remained independently inadmissible. Even if the general admissibility of the report does not necessarily give a green light to multiple layers of hearsay, we conclude that only 2 of the 11 challenged findings constituted hearsay within hearsay. And even if there was error in admitting those findings, neither is of sufficient consequence to warrant reversal. See Liggett v. People, Colorado 2006, explaining that under harmless error review, we will reverse only if, viewing the evidence as a whole, the error substantially influenced the outcome or impaired the fairness of the trial, and that, quote, "in the context of a bench trial, the prejudicial effect of improperly admitted evidence is generally presumed innocuous," end quote. First, the report cited a newspaper article stating that the election was called for President Biden. Although this is hearsay, the district court did not rely on the statement in its analysis, so President Trump was not prejudiced by any error in admitting this statement. See Rail v. People, Colorado, 2006. Quote, "There is no reasonable probability that Rail was prejudiced by the admission of the statements. Thus, the trial court's error was harmless." End quote. Second, the report explained that Chief of Staff Mark Meadows told White House counsel Pat Cipollone that President Trump, quote, "doesn't want to do anything," end quote, to stop the violence. House Resolution Report No. 117-663 at 110. The fact that this statement is hearsay is irrelevant. The district court expressly noted that, quote, "it has only considered those portions of the January 6th report which are referenced in this order and has considered no other portions in reaching its decision," end quote. Anderson, paragraph 38. And it did not mention this statement in its order, nor did it rely on it to reach any conclusions. Thus, President Trump's embedded hearsay argument is unavailing. For these reasons, we conclude that the district court did not abuse its discretion by admitting portions of the report into evidence. We now consider the district court's findings that President Trump engaged in an insurrection within the meaning of Section 3. G. President Trump engaged in insurrection. President Trump challenges the district court's findings that he engaged in an insurrection. The Constitution leaves these terms undefined. Therefore, we must make a legal determination regarding what the drafters and ratifiers meant when they chose to deploy these words in Section 3. Mindful of the deferential standard of review afforded a district court's factual findings, we conclude that the district court did not clearly err in concluding that the events of January 6th constituted an insurrection, and that President Trump engaged in that insurrection. 1. Standard of review. As a general matter, we review findings of fact under either a clear error or abuse of discretion standard, and we review legal conclusions de novo. When, however, the issue before an appellate court presents a mixed question of law and fact, Colorado courts have taken different approaches depending on the circumstances. For example, courts have sometimes treated the ultimate conclusion as one of fact and applied the clear error standard. In other cases, courts have concluded that a mixed question of law and fact mandates de novo review. And when a trial court made evidentiary findings of fact in support of its application of a legal principle from another jurisdiction, we have found it appropriate to conduct an abuse of discretion review of the evidentiary factual findings supporting the legal conclusion and a de novo review of the legal conclusion itself. For our purposes here, where we are called on to review the district court's construction of certain terms used in Section 3 to the facts established by the evidence, we will review the district court's factual findings for clear error and its legal conclusions de novo. 2. Insurrection. Dictionaries, both old and new, the district court's order, and the briefing by the parties and the amici curiae suggest several definitions of the word insurrection. For example, Noah Webster's dictionary from 1860 defined insurrection as a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in a city or state. It is equivalent to sedition, except that sedition expresses a less extensive rising of citizens. It differs from rebellion, for the latter expresses a revolt or an attempt to overthrow the government, to establish a different one, or to place the country under another jurisdiction. Noah Webster, An American Dictionary of the English Language, 1860. Accord, John Bouvier, A Law Dictionary adapted to the Constitution and laws of the United States of America and of the several states to the American Union, 6th edition, 1856, defining insurrection as, quote, a rebellion of citizens or subjects of a country against its government, end quote. Webster's Third New International Dictionary defines insurrection as, quote, an act or instance of revolting against civil or political authority or against an established government, end quote, or, quote, an act or instance of rising up physically, end quote. Insurrection Webster's Third New International Dictionary, 2002. In light of these and other proffered definitions, the district court concluded that, quote, an insurrection, as used in Section 3, is 1. A public use of force or threat of force, 2. By a group of people, 3. To hinder or prevent execution of the Constitution of the United States, end quote. Anderson, paragraph 240. Finally, we note that at oral argument, President Trump's counsel, while not providing a specific definition, argued that an insurrection is more than a riot but less than a rebellion. We agree that an insurrection falls along a spectrum of related conduct. See the Brig Amy Warwick, The Prize Cases, 1862. Quote, insurrection against a government may or may not culminate in an organized rebellion, but a civil war always begins by insurrection against the lawful authority of the government. End quote. Case of Davis, 1871. Quote, although treason by levying war in a case of civil war may involve insurrection or rebellion, and they are usually its first stages, they do not necessarily reach to the actual levying of war. End quote. 77 CJS Riot, Insurrection, Section 36, Westlaw, database updated August 2023. Quote, insurrection is distinguished from rout, riot, and offenses connected with mob violence by the fact that, in insurrection, there is an organized and armed uprising against authority or operations of government, while crimes growing out of mob violence, however serious they may be, and however numerous the participants, are simply unlawful acts in disturbance of the peace, which do not threaten the stability of the government or the existence of political society. End quote. But we part company with him when he goes one step further. No authority supports the position taken by President Trump's counsel at oral argument that insurrectionary conduct must involve a particular length of time or geographic location. Although we acknowledge that these definitions vary, and some are arguably broader than others, for purposes of deciding this case, we need not adopt a single, all-encompassing definition of the word insurrection. Rather, it suffices for us to conclude that any definition of insurrection, for purposes of Section 3, would encompass a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transfer of power in this country. The required force or threat of force need not involve bloodshed, nor must the dimensions of the effort be so substantial as to ensure probable success. Moreover, although those involved must act in a concerted way, they need not be highly organized at the insurrection's inception. See Home Insurance Company of New York v. Davila, 1954. Quote, at its inception, an insurrection may be a pretty loosely organized affair. It may start as a sudden surprise attack upon the civil authorities of a community with incidental destruction of property by fire or pillage, even before the military forces of the constituted government have been alerted and mobilized into action to suppress the insurrection. End quote. The question thus becomes whether the evidence before the district court sufficiently established that the events of January 6th constituted a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish the peaceful transfer of power in this country. We have little difficulty concluding that substantial evidence in the record supported each of these elements and that, as the district court found, the events of January 6th constituted an insurrection. It is undisputed that a large group of people forcibly entered the Capitol and that this action was so formidable that the law enforcement officers on site could not control it. Moreover, contrary to President Trump's assertion that no evidence in the record showed that the mob was armed with deadly weapons or that it attacked law enforcement officers in a manner consistent with a violent insurrection, the district court found, and millions of people saw on live television, recordings of which were introduced into evidence in this case, that the mob was armed with a wide array of weapons. The court also found that many in the mob stole objects from the Capitol's premises or from law enforcement officers to use as weapons, including metal bars from the police barricades and officers' batons and riot shields, and that, throughout the day, the mob repeatedly and violently assaulted police officers who were trying to defend the Capitol. The fact that actual and threatened force was used that day cannot reasonably be denied. Substantial evidence in the record further established that this use of force was concerted and public. As the district court found, with ample record support, quote, the mob was coordinated and demonstrated a unity of purpose. They marched through the Capitol building chanting in a manner that made clear they were seeking to inflict violence against members of Congress and Vice President Pence, end quote. And upon breaching the Capitol, the mob immediately pursued its intended target, the certification of the presidential election, and reached the House and Senate chambers within minutes of entering the building. Finally, substantial evidence in the record showed that the mob's unified purpose was to hinder or prevent Congress from counting the electoral votes, as required by the 12th Amendment, and from certifying the 2020 presidential election. That is, to preclude Congress from taking the actions necessary to accomplish a peaceful transfer of power. As noted above, soon after breaching the Capitol, the mob reached the House and Senate chambers, where the certification process was ongoing. This breach caused both the House and the Senate to adjourn, halting the electoral certification process. In addition, much of the mob's ire, which included threats of physical violence, was directed at Vice President Pence, who, in his role as President of the Senate, was constitutionally tasked with carrying out the electoral count. As discussed more fully below, these actions were the product of President Trump's conduct in singling out Vice President Pence for refusing President Trump's demand that the Vice President decline to carry out his constitutional duties. In short, the record amply established that the events of January 6th constituted a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish the peaceful transfer of power in this country. Under any viable definition, this constituted an insurrection. And thus, we will proceed to consider whether President Trump engaged in this insurrection. 3. Engaged in. Dictionaries, historical evidence, and case law all shed light on the meaning of engaged in, as that phrase is used in Section 3. Noah Webster's dictionary from 1860 defined engage as to embark in an affair. Noah Webster, An American Dictionary of the English Language, 1860. Similarly, Webster's Third New International Dictionary defines engage as to begin and carry on an enterprise, or to take part, or participate. Engage, Webster's Third New International Dictionary, 2002. And Merriam-Webster defines engage as including both to induce to participate and to do or take part in something. Engage, Merriam-Webster Dictionary. Attorney General Stanberry's opinions on the meaning of engage, which he issued at the time the 14th Amendment was being debated, are in accord with these historical and modern definitions. Attorney General Stanberry opined that a person may engage in insurrection or rebellion, quote, without having actually levied war or taken arms, end quote. Thus, in Attorney General Stanberry's view, when individuals acting in their official capacities act, quote, in the furtherance of the common unlawful purpose, end quote, or do, quote, any overt act for the purpose of promoting the rebellion, end quote, they have engaged in insurrection or rebellion for Section 3 disqualification purposes. Accordingly, quote, disloyal sentiments, opinions, or sympathies would not disqualify. But when a person has, by speech or by writing, incited others to engage in rebellion, he must come under the disqualification, end quote. Turning to case law construing the meaning of engaged in for purposes of Section 3, although we have found little precedent directly on point, Cases concerning treason that had been decided by the time the 14th Amendment was ratified provide some insight into how the drafters of the 14th Amendment would have understood the term engaged in. For example, in Ex parte Bowman, 1807, Chief Justice Marshall explained that, quote, "If a body of men be actually assembled for the purpose of effecting by force a treasonable purpose, all those who perform any part, however minute or however remote from the scene of action, and who are actually leagued in the general conspiracy, are to be considered as traitors." End quote. In other words, an individual need not directly participate in the overt act of levying war or insurrection for the law to hold him accountable as if he had. It is not necessary to prove that the individual accused was a direct personal actor in the violence. If he was present, directing, aiding, abetting, counseling, or countenancing it, he is in law guilty of the forcible act. Nor is even his personal presence indispensable. Though he be absent at the time of its actual perpetration, yet if he directed the act, devised or knowingly furnished the means for carrying it into effect, instigating others to perform it, he shares their guilt. In treason there are no accessories. In charge to grand jury, treason. Pennsylvania, 1851. We find the foregoing definitions and authorities to be generally consistent, and we believe that the definition adopted and applied by the District Court is supported by the plain meaning of the term engaged in, as well as by the historical authorities discussed above. Accordingly, like the District Court, we conclude that engaged in requires, quote, "an overt and voluntary act done with the intent of aiding or furthering the common unlawful purpose," end quote. Anderson, paragraph 254. In so concluding, we hasten to add that we do not read engaged in so broadly as to subsume mere silence in the face of insurrection or mere acquiescence therein, at least absent an affirmative duty to act. Rather, as Attorney General Stanbury observed, quote, "The force of the term to engage carries the idea of active rather than passive conduct, and of voluntary rather than compulsory action." End quote. See also Bode and Paulson, Supra, manuscript at 67, noting that, quote, "passive acquiescence, resigned acceptance, silence, or inaction is not typically enough to have engaged in insurrection or rebellion unless a person possesses an affirmative duty to speak or act." End quote. The question remains whether the record supported the District Court's finding that President Trump engaged in the January 6th insurrection by acting overtly and voluntarily with the intent of aiding or furthering the insurrectionists' common unlawful purpose. Again, mindful of our applicable standard of review, we conclude that it did, and we proceed to a necessarily detailed discussion of the evidence to show why this is so. Substantial evidence in the record showed that even before the November 2020 general election, President Trump was laying the groundwork for a claim that the election was rigged. For example, at an August 17, 2020 campaign rally, he said that, quote, "The only way we're going to lose this election is if the election is rigged," end quote. Moreover, when asked at a September 23, 2020 press briefing whether he would commit to a peaceful transfer of power after the election, President Trump refused to do so. President Trump then lost the election, and despite the facts that his advisers repeatedly advised him that there was no evidence of widespread voter fraud, and that no evidence showed that he himself believed the election was wrought with fraud, President Trump ramped up his claims that the election was stolen from him and undertook efforts to prevent the certification of the election results. For example, in a December 13, 2020 tweet, he stated, quote, "Swing states that have found massive voter fraud, which is all of them, cannot legally certify these votes as complete and correct without committing a severely punishable crime," end quote. And President Trump sought to overturn the election results by directly exerting pressure on Republican officeholders in various states. On this point, and relevant to President Trump's intent in this case, many of the state officials targeted by President Trump's efforts were subjected to a barrage of harassment and violent threats by his supporters. President Trump was well aware of these threats, particularly after Georgia election official Gabriel Sterling issued a public warning to President Trump to, quote, stop inspiring people to commit potential acts of violence, end quote, or, quote, someone's going to get killed, end quote. President Trump responded by retweeting a video of Sterling's press conference with a message repeating the very rhetoric that Sterling warned would result in violence. And President Trump continued to fan the flames of his supporters' ire, which he had ignited with ongoing false assertions of election fraud, propelling the Stop the Steal movement and cross-country rallies leading up to January 6th. Specifically, between Election Day 2020 and January 6th, Stop the Steal organizers held dozens of rallies around the country, proliferating President Trump's election disinformation and recruiting attendees, including members of violent extremist groups like the Proud Boys, the Oath Keepers, and the 3%ers, QAnon conspiracy theorists, and white nationalists to travel to Washington, D.C. on January 6th. Stop the Steal leaders also joined 2 million MAGA marches in Washington, D.C. on November 14, 2020 and December 12, 2020. Again, as relevant to President Trump's intent here, after the November rally turned violent, President Trump acknowledged the violence but justified it as self-defense against Antifa scum. With full knowledge of these sometimes violent events, President Trump sent the following tweet on December 19, 2020, urging his supporters to travel to Washington, D.C. on January 6th. Quote, statistically impossible to have lost the 2020 election. Big protest in D.C. on January 6th. Be there, will be wild. End quote. At this point, the record established that President Trump's plan was that when Congress met to certify the election results on January 6th, Vice President Pence could reject the true electors who voted for President Biden and certify a slate of fake electors supporting President Trump, or he could return the slates to the states for further proceedings. Far-right extremists and militias such as the Proud Boys, the Oath Keepers, and the 3%ers viewed President Trump's December 19, 2020 tweet as a call to arms, and they began to plot activities to disrupt the January 6th joint session of Congress. In the meantime, President Trump repeated his invitation to come to Washington, D.C. on January 6th at least 12 times. On December 26, 2020, President Trump tweeted, if a Democrat presidential candidate had an election rigged and stolen, with proof of such acts at a level never seen before, the Democrat senators would consider it an act of war and fight to the death. Mitch McConnell and the Republicans do nothing, just want to let it pass. No fight. And on January 1, 2021, President Trump retweeted a post from Kylie Jane Kramer, an organizer of the scheduled January 6th March for Trump, that stated, quote, the cavalry, Sikh, is coming, Mr. President. January 6th, Washington, D.C., end quote. President Trump added to his retweet, quote, a great honor, end quote. The foregoing evidence established that President Trump's messages were a call to his supporters to fight, and that his supporters responded to that call. Further supporting such a conclusion was the fact that multiple federal agencies, including the Secret Service, identified significant threats of violence in the days leading up to January 6th. These threats were made openly online, and they were widely reported in the press. Agency threat assessments thus stated that domestic violent extremists planned for violence on January 6th with weapons, including firearms and enough ammunition to, quote, win a small war, end quote. Along the same lines, the Federal Bureau of Investigation received many tips regarding the potential for violence on January 6th. One tip said, they think they will have a large enough group to march into D.C. armed and will outnumber the police so they can't be stopped. They believe that since the election was stolen. It's their constitutional right to overtake the government, and during this coup, no U.S. laws apply. Their plan is to literally kill. Please take this tip seriously and investigate further. The record reflects that President Trump had reason to know of the potential for violence on January 6th. As president, he oversaw the agencies reporting the foregoing threats. In addition, Katrina Pearson, a senior advisor to both of President Trump's presidential campaigns, testified on behalf of President Trump that at a January 5, 2021 meeting, President Trump chose the speakers for the January 6th event at which he, too, would speak, avoiding at least some extremist speakers, and that he knew that radical political extremists were going to be in Washington, D.C. on January 6th and would likely attend his speech. January 6th arrived, and in the early morning, President Trump tweeted, quote, "If Vice President Mike Pence comes through for us, we will win the presidency. Many states want to decertify the mistake they made in certifying incorrect and even fraudulent numbers in a process not approved by their state legislatures, which it must be. Mike can send it back." End quote. He followed this tweet later that morning with another that said, quote, "All Mike Pence has to do is send them back to the states, and we win. Do it, Mike. This is a time for extreme courage." End quote. These tweets had the obvious effect of putting a significant target on Vice President Pence's back, focusing Trump's supporters on the vice president's role in overseeing the counting of the electoral votes and certifying the 2020 presidential election to ensure the peaceful transfer of power. At about this same time, tens of thousands of President Trump supporters began gathering around the ellipse for his speech. To enter the ellipse itself, attendees were required to pass through magnetometers. Notably, from the approximately 28,000 attendees who passed through these security checkpoints, the Secret Service confiscated hundreds of weapons and other prohibited items, including knives or blades, pepper spray, brass knuckles, tasers, body armor, gas masks, and batons or blunt instruments. Approximately 25,000 additional attendees remained outside the Secret Service perimeter, thus avoiding the magnetometers. President Trump then gave a speech in which he literally exhorted his supporters to fight at the Capitol. Among other things, he told the crowd, quote, "We're gathered together in the heart of our nation's capital for one very, very basic reason, to save our democracy." End quote. Quote, "Republicans are constantly fighting like a boxer with his hands tied behind his back. It's like a boxer, and we want to be so nice. We want to be so respectful of everybody, including bad people. And we're going to have to fight much harder." End quote. Quote, "Now it is up to Congress to confront this egregious assault on our democracy. And after this, we're going to walk down, and I'll be there with you." End quote. Quote, "We're going to walk down to the Capitol, and we're going to cheer on our brave senators and congressmen and women, and we're probably not going to be cheering so much for some of them, because you'll never take back our country with weakness. You have to show strength, and you have to be strong." End quote. Quote, "When you catch somebody in a fraud, you're allowed to go by very different rules." End quote. Quote, "This is the most corrupt election in the history, maybe of the world. This is not just a matter of domestic politics. This is a matter of national security." End quote. Quote, "And we fight. We fight like hell, and if you don't fight like hell, you're not going to have a country anymore." End quote. Unsurprisingly, the crowd at the ellipse reacted to President Trump's words with calls for violence. Indeed, after President Trump instructed his supporters to march to the Capitol, members of the crowd shouted, "Storm the Capitol," "Invade the Capitol building," and "Take the Capitol." And before he had even concluded his speech, President Trump's supporters followed his instructions. The crowd marched to the Capitol, many carrying Revolutionary War flags and Confederate battle flags, quickly breached the building, and immediately advanced to the House and Senate chambers to carry out their mission of blocking the certification of the 2020 presidential election. By 1:21 p.m., President Trump was informed that the Capitol was under attack. Rather than taking action to end the siege, however, approximately 1 hour later, at 2:24 p.m., he tweeted, quote, "Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones which they were asked to previously certify. USA demands the truth." End quote. This tweet was read over a bullhorn to the crowd at the Capitol and produced further violence, necessitating the evacuation of Vice President Pence from his Senate office to a more secure location to ensure his physical safety. President Trump's next public communications were two tweets sent at 2:38 p.m. and 3:13 p.m., encouraging the mob to remain peaceful and to stay peaceful. Obviously, the mob was not at all peaceful, but neither tweet condemned the violence nor asked the mob to disperse. Throughout these several hours, President Trump ignored pleas to intervene and instead called on senators, urging them to help delay the electoral count, which is what the mob, upon President Trump's exhortations, was also trying to achieve. And President Trump took no action to put an end to the violence. To the contrary, as mentioned above, when told that the mob was chanting, "Hang Mike Pence," President Trump responded that perhaps the vice president deserved to be hanged. President Trump also rejected pleas from House Republican leader Kevin McCarthy, imploring him to tell his supporters to leave the Capitol, stating, quote, "Well, Kevin, I guess these people are more upset about the election than you are," end quote. Finally, at 4:17 p.m., President Trump released a video urging the mob, quote, "to go home now," end quote. Even then, he did not condemn the mob's actions. Instead, he sympathized with those who had violently overtaken the Capitol, telling them that he knew their pain. He told them that he loved them and that they were very special. And he repeated his false claim that the election had been stolen notwithstanding his landslide victory, thereby further endorsing the mob's effort to try to stop the peaceful transfer of power. A short while later, President Trump reiterated this supportive message to the mob by justifying its actions, tweeting at 6:01 p.m., quote, "These are the things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from great patriots who have been badly and unfairly treated for so long. Go home with love and in peace," end quote. President Trump concluded by encouraging the country to, quote, "remember this day forever," end quote. We conclude that the foregoing evidence, the great bulk of which was undisputed at trial, established that President Trump engaged in insurrection. President Trump's direct and express efforts over several months exhorting his supporters to march to the Capitol to prevent what he falsely characterized as an alleged fraud on the people of this country were indisputably overt and voluntary. Moreover, the evidence amply showed that President Trump undertook all these actions to aid and further a common unlawful purpose that he himself conceived and set in motion: prevent Congress from certifying the 2020 presidential election and stop the peaceful transfer of power. We disagree with President Trump's contentions that the record does not support a finding that he engaged in an insurrection because 1. Engage does not include incite, and 2. He did not have the requisite intent to aid or further the insurrectionists' common unlawful purpose. As our detailed recitation of the evidence shows, President Trump did not merely incite the insurrection. Even when the siege on the Capitol was fully underway, he continued to support it by repeatedly demanding that Vice President Pence refuse to perform his constitutional duty, and by calling senators to persuade them to stop the counting of electoral votes. These actions constituted overt, voluntary, and direct participation in the insurrection. Moreover, the record amply demonstrates that President Trump fully intended to, and did, aid or further the insurrectionists' common unlawful purpose of preventing the peaceful transfer of power in this country. He exhorted them to fight to prevent the certification of the 2020 presidential election. He personally took action to try to stop the certification, and for many hours he and his supporters succeeded in halting that process. For these reasons, we conclude that the record fully supports the district court's finding that President Trump engaged in insurrection within the meaning of Section 3. H. President Trump's speech on January 6th was not protected by the First Amendment right to freedom of speech. President Trump contends that his speech on January 6th was protected by the First Amendment and therefore cannot be used to justify his disqualification from office under Section 3. The district court concluded that this speech was unprotected by the First Amendment. We agree with the district court. 1. Standard of review. In considering President Trump's First Amendment challenge, we undertake an, quote, independent review of the record to be sure that the speech in question actually falls within an unprotected category, end quote, of communication. Bose Corporation v. Consumers Union of U.S., Inc., 1984. We have interpreted this independent review as being akin to de novo review. Bose recognizes, however, that we may give some presumption of correctness to factual findings, especially those that do not involve the application of standards of law, or those that arise from complex cases such as this one, where the district judge has lived with the controversy. Focusing on the findings by the district court, we therefore, quote, examine for ourselves the statements in issue and the circumstances under which they were made to see whether they are of a character which the principles of the First Amendment protect." End quote. 2. First Amendment protections and incitement. The First Amendment to the U.S. Constitution provides that, quote, Congress shall make no law abridging the freedom of speech, end quote. U.S. Constitution, Amendment 1. This robust protection for speech functions to invite dispute. Terminiello v. Chicago, 1949, and, quote, was fashioned to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people, end quote. Roth v. United States, 1957. See also New York Times Company v. Sullivan, 1964. Even so, quote, the right of free speech is not absolute at all times and under all circumstances, end quote. Chaplinsky v. New Hampshire, 1942. The First Amendment does not protect, for example, true threats. Watts v. United States, 1969. Speech essential to criminal conduct, Packingham v. North Carolina, 2017, or speech that incites lawless action, Brandenburg v. Ohio, 1969. It is this last strand of First Amendment jurisprudence that the parties debate here. As the Supreme Court explained in Brandenburg, the First Amendment's, quote, constitutional guarantees of free speech do not permit a state to forbid or proscribe advocacy of the use of force or of law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action, end quote. Under Brandenburg and its progeny, the modern test to determine whether speech is unprotected under the First Amendment because it incited lawless action is whether 1. The speech explicitly or implicitly encouraged the use of violence or lawless action, 2. The speaker intended that the speech would result in the use of violence or lawless action, and 3. The imminent use of violence or lawless action was the likely result of the speech. Nwanguma v. Trump, 2018, Accord Bible Believers v. Wayne County, 2015. 3. Applying the Brandenburg test. A. Context. President Trump contends that the district court erred by examining the broader context in which President Trump's speech was made, thereby, quote, expanding the context relevant to a Brandenburg analysis beyond anything recognized in precedent, end quote. He asserts that we should examine his speech only in the narrow context in which it was made. We disagree. In Schenck v. United States, 1919, the Supreme Court addressed for the first time, advocacy of illegal conduct, and it recognized the importance of context in holding that, quote, "The character of every act depends upon the circumstances in which it is done," end quote. Although the Supreme Court has said little about how to analyze incitement since Brandenburg, it offered some guidance regarding a court's use of other statements for context in NAACP v. Claiborne Hardware Company, 1982. In Claiborne Hardware, the court considered speeches given by Charles Evers, the field secretary of the Mississippi NAACP, in connection with the NAACP's boycott of white merchants in Claiborne County from 1966 to 1969. Evers declared to black residents of Claiborne County that, quote, "blacks who traded with white merchants would be answerable to him," end quote, and that, quote, "any Uncle Toms who broke the boycott would have their necks broken by their own people," end quote. Ibid. Evers' statements also included that, quote, "boycott violators would be disciplined by their own people," end quote, and he, quote, "warned that the sheriff could not sleep with boycott violators at night," end quote. Ibid. The court held that Evers' speeches were protected by the First Amendment, but said that, quote, "if there was other evidence of Evers' authorization of wrongful conduct, the references to discipline in the speeches could be used to corroborate that evidence." Ibid. By considering and placing value in the absence of corroborating evidence of Evers' violent intentions, the court implied that courts may look to circumstances beyond the speech itself to determine intent. See United States v. White, 2010, relying on Claiborne Hardware in denying a motion to dismiss in a solicitation case based on the existence of, quote, "further evidence of the relationship between the defendant and his followers, which will show the posting was a specific request to the defendant's followers," end quote. While incitement precedent is sparse, the case law on true threats is instructive regarding the importance of context. True threats and incitement are doctrinally distinct, but true threats are the closest cousin to incitement under the First Amendment. Counterman v. Colorado, 2023, Sotomayor, J., concurring in part. Accord, United States v. Howell, 1983, quote, "the line between the two forms of speech, incitement and true threats, may be difficult to draw in some instances," end quote. See also G. Robert Blakey and Brian J. Murray, Threats, Free Speech, and the Jurisprudence of the Federal Criminal Law, 2002 BYU Law Review, explaining that both exceptions involve exhortations regarding violence that derive from Schenk's clear and present danger test. And multiple federal circuit courts conducting a true threat analysis confirm what common sense suggests. When assessing whether someone means to threaten another with unlawful violence, we sometimes need to consider more than the behavior exhibited on one occasion. See e.g. Planned Parenthood of the Columbia Willamette, Inc. v. American Coalition of Life Activists, 2002, rejecting an argument that context means the direct circumstances surrounding delivery of the threat, and instead concluding that, quote, "we, and so far as we can tell, other circuits as well, consider the whole factual context and all of the circumstances in order to determine whether a statement is a true threat," end quote. Quoting United States v. Merrill, 1984, and United States v. Hanna, 2002. United States v. Hart, 2000, considering, quote, "whether the maker of the threat had made similar statements to the victim on other occasions," end quote, and, quote, "whether the victim had reason to believe that the maker of the threat had a propensity to engage in violence," end quote, when determining whether a true threat exists. So, too, with incitement. Context matters. This is not to say, as President Trump contends the district court found, that we, quote, "may consider any speech ever uttered by President Trump," end quote, in evaluating incitement. Of course, there are limits, but we need not define those outer limits now. Instead, we simply conclude that it was appropriate for the district court to consider President Trump's, quote, history of courting extremists and endorsing political violence as legitimate and proper, as well as his efforts to undermine the legitimacy of the 2020 election results and hinder the certification of the Electoral College results in Congress. With this in mind, we review the District Court's application of Brandenburg's three-pronged test. B. Encouraging the use of violence or lawless action. Again, the first prong of the test for incitement is that, quote, the speech explicitly or implicitly encouraged the use of violence or lawless action, end quote. The District Court made dozens of findings regarding the general atmosphere of political violence that President Trump created before January 6th, many of which we have already outlined in discussing why the District Court concluded that President Trump engaged in insurrection. We incorporate those observations here by reference and supplement them with other illuminating evidence from the record below. For example, the District Court found that, quote, at a February 2016 rally, President Trump told his supporters that in the old days a protester would be carried out on a stretcher and that he would like to punch him in the face, end quote. In March 2016, President Trump responded to questions about his supporters' violence by saying it was very, very appropriate and we need a little bit more of it. And during the 2020 election cycle, quote, President Trump threatened to deploy the military to Minneapolis to shoot looters amid protests over the police killing of George Floyd, end quote, and told the Proud Boys to, quote, stand back and stand by, end quote, during a debate for the 2020 presidential election. The District Court also credited the testimony of Professor Peter Simi, a professor of sociology at Chapman University, whom it had, quote, qualified as an expert in political extremism, including how extremists communicate and how the events leading up to and including the January 6th attack relate to long-standing patterns of behavior and communication by political extremists. He testified, according to the court's summary, that one, quote, violent far-right extremists understood that President Trump's calls to fight, which most politicians would mean only symbolically, were, when spoken by President Trump, literal calls to violence by these groups, while President Trump's statements negating that sentiment were insincere and existed to obfuscate and create plausible deniability, end quote. And that, too, quote, President Trump's speech took place in the context of a pattern of President Trump's knowing encouragement and promotion of violence to develop and deploy a shared, coded language with his violent supporters, end quote. As we described in the foregoing section, the District Court further found that President Trump encouraged and supported violence before and after the 2020 election by telling his supporters that, quote, the only way we're going to lose this election is if the election is rigged. Remember that, end quote. That the election was a fraud on the American public, and that the Democrats had stolen an election that rightfully belonged to President Trump and his supporters. The District Court also found that, quote, many of the state officials targeted by President Trump's campaign of intimidation were subject to a barrage of harassment and violent threats by his supporters, prompting Georgia election official Gabriel Sterling to issue a public warning to President Trump to stop inspiring people to commit potential acts of violence, or someone's going to get killed. The District Court then identified specific incendiary language in President Trump's speech at the Ellipse on January 6th, some of which we alluded to earlier in this opinion. To reiterate, President Trump announced, quote, we're going to walk down, and I'll be with you. We're going to walk down to the Capitol, end quote. He used the word fight, or variations of it, 20 times during his Ellipse speech. Quote, and we fight like hell, and if you don't fight like hell, you're not going to have a country anymore, end quote. He declared, quote, when you catch somebody in a fraud, end quote, a sentiment he had repeatedly said had occurred with the 2020 election, quote, you're allowed to go by very different rules, end quote. Quote, you don't concede when there's theft involved, end quote. And he claimed that, quote, Our election victory was stolen by emboldened radical left Democrats, end quote. In short, the district court found that President Trump's speech at the ellipse, quote, was understood by a portion of the crowd as a call to arms, end quote. And the district court here is not the first or only court to reach this conclusion. In Thompson v. Trump, 2022, the U.S. District Court for the District of Columbia found that President Trump invited his supporters to Washington, D.C., after telling them for months that corrupt and spineless politicians were to blame for stealing an election from them, retold that narrative when thousands of them assembled on the ellipse, and directed them to march on the Capitol building, where those very politicians were at work to certify an election that he had lost. The court concluded that President Trump's speech was therefore, quote, plausibly a positive instigation of a mischievous act, end quote. Quoting John Stuart Mill on Liberty 100, 1859. Our independent review of the record in this case brings us to the same conclusion. President Trump incited and encouraged the use of violence and lawless action to disrupt the peaceful transfer of power. The tenor of President Trump's messages to his supporters in exhorting them to travel to Washington, D.C. on January 6th was obvious and unmistakable. The allegedly rigged election was an act of war, and those victimized by it had an obligation to fight back and to fight aggressively. And President Trump's supporters did not miss or misunderstand the message. The cavalry was coming to fight. The fact that, at one point during his speech, President Trump said that, quote, everyone here will soon be marching to the Capitol building to peacefully and patriotically make your voices heard, end quote, does not persuade us that the district court erred in finding that the first prong of the Brandenburg test was met. This isolated reference, quote, cannot inoculate President Trump against the conclusion that his exhortation, made nearly an hour later to fight like hell immediately before sending rallygoers to the Capitol, within the context of the larger speech and circumstances, was not protected expression, end quote. C. Intent to produce violent or lawless action. The second prong of the test for incitement is that, quote, the speaker intends that his speech will result in the use of violence or lawless action, end quote. The Supreme Court has interpreted this second prong of the Brandenburg test to require specific intent. Counterman, establishing that, quote, when incitement is at issue, we have spoken in terms of specific intent, presumably equivalent to purpose or knowledge, end quote, and defining acting purposely as, quote, consciously desiring a result, end quote. So we must consider whether President Trump's exhortations at the ellipse on January 6th to fight like hell and his urgings that his followers go to the Capitol and that they would get to go by very different rules were intended to produce imminent lawless action. The district court concluded that President Trump exhibited the requisite intent here. It found that, before the January 6th rally, quote, President Trump knew that his supporters were angry and prepared to use violence to stop the steal, including physically preventing Vice President Pence from certifying the election, end quote, and that President Trump's response to the events following his speech, quote, support that President Trump endorsed and intended the actions of the mob on January 6th, end quote. Based on these findings of fact, the court, quote, concluded that President Trump acted with the specific intent to incite political violence and direct it at the Capitol with the purpose of disrupting the electoral certification, end quote. The district court found that President Trump knew, before he gave his speech, that there was the potential for violence on January 6th. It found that, quote, President Trump himself agrees that his supporters listened to him like no one else, end quote, and that federal agencies that President Trump oversaw identified threats of violence ahead of January 6th, including, quote, threats to storm the U.S. Capitol and kill elected officials, end quote. The court also found that President Trump's conduct and tweets, which we outlined above, from the time he was told of the attack on the Capitol at 1:21 p.m. until Congress reconvened later that night, indicated his intent to produce lawless or violent conduct. In conducting our independent review of the district court's factual findings, we agree that President Trump intended that his speech would result in the use of violence or lawless action on January 6th to prevent the peaceful transfer of power. Despite his knowledge of the anger that he had instigated, his calls to arms, his awareness of the threats of violence that had been made leading up to January 6th, and the obvious fact that many in the crowd were angry and armed, President Trump told his riled-up supporters to walk down to the Capitol and fight. He then stood back and let the fighting happen, despite having the ability and authority to stop it, with his words or by calling in the military, thereby confirming that this violence was what he intended. We therefore conclude that the second prong of the Brandenburg test has also been met. D. Likely to incite or produce imminent lawless action. Finally, for speech to be unprotected, we must conclude that, quote, the imminent use of violence or lawless action is the likely result of the speech, end quote. The district court found that Professor Simi reviewed President Trump's relationship with his supporters over the years, identified a pattern of calls for violence that his supporters responded to, and explained how that long experience allowed President Trump to know how his supporters responded to his calls for violence, using a shared language that allowed him to maintain plausible deniability with the wider public. Professor Simi then, quote, testified about examples of these patterns of call and response that President Trump developed and used to incite violence by his supporters. In one such instance, a November 2015 political rally, quote, President Trump told his supporters to get a protester the hell out of here, and the protester was then assaulted. When asked about the attack the next day, Trump said, maybe the protester should have been roughed up, end quote. Further, the district court found that, quote, on January 1, 2021, President Trump retweeted a post from Kylie Jane Kremer, an organizer of March for Trump on January 6, saying, the cavalry, is coming, Mr. President, end quote. It found that, according to Professor Simi, quote, President Trump's December 19, 2020, will be wild tweet had an immediate effect on far-right extremists and militias, who viewed the tweet as a call to arms and began to plot activities to disrupt the January 6, 2021 joint session. These findings support the conclusion that President Trump's calls for imminent lawlessness and violence during his speech were likely to incite such imminent lawlessness and violence. When President Trump told his supporters that they were allowed to go by very different rules, and that if they did not fight like hell, they would not have a country anymore, it was likely that his supporters would heed his encouragement and act violently. We therefore hold that this final prong of the Brandenburg test has been met. In sum, we conclude that President Trump's speech on January 6th was not protected by the First Amendment. 4. Conclusion. The district court erred by concluding that Section 3 does not apply to the President. We therefore reverse the district court's judgment. As stated above, however, we affirm much of the district court's reasoning on other issues. Accordingly, we conclude that because President Trump is disqualified from holding the office of President under Section 3, it would be a wrongful act under the Election Code for the Secretary to list President Trump as a candidate on the presidential primary ballot. Therefore, the Secretary may not list President Trump's name on the 2024 presidential primary ballot, nor may she count any write-in votes cast for him. See Colorado Revised Statute, quote, a vote for a write-in candidate shall not be counted unless that candidate is qualified to hold the office for which the elector's vote was cast, end quote. But we stay our ruling until January 4, 2024, the day before the Secretary's deadline to certify the content of the presidential primary ballot. If review is sought in the Supreme Court before the stay expires, it shall remain in place, and the Secretary will continue to be required to include President Trump's name on the 2024 presidential primary ballot until the receipt of any order or mandate from the Supreme Court. This concludes this episode of The Docket. I hope you enjoyed this episode. For updates on the docket, please visit docketpod.com or find us on Threads as DocketPod. If you found this useful or interesting, please consider subscribing to the docket and supporting my Patreon at patreon.com/docketpod. Thank you.